There was one question I wanted to ask to the respondents.
Lot.
There is a order passed by coordinate bench in while grant of stay, I think,
In the IA.
in the IA.
Lot.
That order has virtually deprecated the actions of the respondents, has given is virtually come to a conclusion. There is no appeal or review against that order.
No man.
There is a finding. What I want to say is that there is a finding.
But that it is there.
So if there is a finding, what are we to do with this finding?
But in fact, while passing the order, the Honorable Court has recorded some of the paragraph of our affidavit and ultimately
No,
Take a-
there is,
take a
where is that order? Where does one find that order? In the IA.
IA, my lord.
IA की बता सकता. Where is the IA? Which IA?
IA 2955 of 24.
2955. Yes. Ah, 2009.
Yes,
In this IA, you come to para 31.
yes, Malad.
See, this is the finding.
But we have filed another application for modification of this order. That is IA number 170 of 2025.
Ah.
We have sought for modification, clarification of this order.
but it
That-
was
If
decided.
clarification, then it has to go before the court which has passed it.
No,
But
my lord.
this IA,
This will amount to review of the order.
IA 170 of 2025 is there. Malad.
No, that is there, but you are asking for, what is the prayer in the IA here?
But in the IA, we have prayed for.
Hmm.
Can you take up the IA, page number 18? Malad?
1818.
Yes, Malad.
Yes. Modify or vacate.
Yes, Malad. Or suitably alter the order dated 29/2024, passed in IA number. So and so.
What was the penultimate direction here?
Penultimate direction, para 40, kindly see, Malad. In the IA, page number 34. The show cause notice dated 2/9/2024 is illegal and as such.
You read from para 36 onwards.
Lodge.
Para 36, para 37, these are all findings. So what modification is necessary here? And this is a inter-party order.
Malad, it's an inter-party order, but Lordship has stayed the show cause notice and kept the repetition pending, Malad. And ultimately, it was hard on merit, Malad.
No, we are only expressing our views. We are not asking you what we should do.
Lodge.
We know what we can do.
Lodge.
We are only pointing it out to you that in the face of this, is there anything you'd like to say? This according to the court is a clear finding. You have not chosen to file a review or an appeal.
Malad, we have not.
Therefore,
we
an
have not filed-
application in an inter-party order where this conclusion is arrived at, your application prima facie merits dismissal for modification. It can't be modified. It will amount to a review.
No, Malad, in the application, we have Malad, stated that while passing the order, Malad, they
Mr. Nath, these are your submissions. Had it been an ex-party order, we could have modified, we could have altered the order. This is an inter-party order. These are conclusions arrived at. What is the remedy? What modification do you want? What specific modification do you want?
Malad,
You are virtually asking that this order should not be given effect to. Then how can it be done by a coordinate bench?
In fact, my lord, when this IA was pressed, my lord, the same view was coming from the court. They said that we will go for the entire hearing of the case. They chose not to press this IA. That's why the entire matter was taken up for hearing.
IA along with the writ petition was taken up.
We are taking it up, but while going through the papers, we noticed this again. And then this question arose, so we are putting it to you.
Malad.
If you say that you have nothing to submit, we'll
No, my lord, we,
close it then.
but Lordship will submit, my lord. In fact, Lordship, my lord, in this matter, I am led by my senior, my lord. My lord, since I have taken note of what the query Lordship has posed, my lord. Lordship may keep the matter, my lord, day after tomorrow, we will respond to that, my lord.
Day after tomorrow will not be possible. We
On
will-
Monday.
Monday or Tuesday, not
Tu-
Monday,
Tuesday. my lord.
Tuesday.
Tuesday. my lord. Because the IA is pending, my lord, we'll respond to that, my lord.
Let it be on 6th then, 6th,
6th, my lord.
6th of November.
Um,
6th of November, on
Lordship,
a prayer made by the.
Can I pray for little indulgence, my lord? I'll just tell the date. I'll just
You
ask
check
my,
up and inform the
Yes, ma'am.
pastor and
Yes.
share the dates with the council.
I'll just ask my senior.
Mr. J. Patwari for the petitioner, Mr. D. Nath, counsel representing the a senior government advocate for the respondent. So, on the prayer made by the senior government advocate, matters stands August 6th, enabling him to address the court in respect of the order dated
29/24, madam.
20/09/2024, passed in IA number 2955
No.
of 24. Has agreed to let this matter be listed again on 6th.
Lordship, I'll just verify the date and I'll apply.
Second three.
Lord, this pertains to rank and pay in the Assam Rifles. Your Lordship goes to the previous orders. Lordship would note that two particular ROIs were directed to be produced. That my learned friend had produced. And in fact, we are given a copy that we have filed in form of an affidavit now. The short issue, my lord, involved herein was that this is basically the remonstration of these people from the trade of operator radio line to ciphers. The cipher is a trade in Assam Rifles in which there is no direct recruitment. That trade always happens from remonstration from ORL. The ORL people have to pass a particular exam and then they are remonstrated into the ciphers. Now, what had happened is that the recruitment rule that subsequently came in, my lord, it said that a period of 8 years, my lord, have to be spent in ORL before you can be made a cipher. Now, as per that recruitment rule, they have fixed the particular date of these particular persons that in 2007, you are therefore remonstrated as ciphers. But in our case, my lord, was that preceding that particular rule, there was a instruction, my lord, circular, which said that as far as ciphers are concerned, this is what the two ROIs basically indicate. As far as ciphers are concerned, immediately after passing of the class trade test, because you have to pass an examination to become a cipher, you can be remonstrated into cipher. And the reason behind is that, my lord, because there is no direct recruitment, unless and until these vacancies are immediately filled up upon passing of the exam, there will be a shortfall of ciphers in the trade. And cipher being an important category, which basically passes on all messages and encryption and secret messages and other, my lord, communications within the force, there cannot be a shortfall. So immediately when this particular persons at that point of time, there were 44 vacancies, they were, my lord, remastered into cipher and given the trade of and duties of cipher. They continue to function. But then officially the date has been wrongly fixed in the 2019 revision, my lord, as 2007, and therefore this petition had come, my lord. So these two ROIs, my lord, I have indicated.
What are the ROIs?
The ROIs, my lord, would see in my additional affidavit. This was filed on 1/9/2025, my lord. Right copy, yes, sir. Acha. My additional, if your lordship comes to page 244. In fact, this clarification had come after the recruitment rule. At page 224, sorry, 244.
Yes.
So as far as cipher is concerned, my lord, there is a star mark. This is basically from rifleman to Havaldar,
In 244.
244. Rifleman to Havaldar,
Hmm.
serial number 1,
Hmm.
ORL, radio mechanic, SKT, EFS, so and so, and cipher. In cipher, there is a star, and as
Hmm.
far as cipher is concerned, they are eligible for promotion to Havaldar on the remarkation.
Yes.
Promotion cadre N1 and N2 pass. So immediately on passing of this to
What is your
examination,
basic rank now?
my lord,
Present rank?
we are warrant officers as of now.
Warrant officers. Warrant officers fall under what? Indicator of?
Cipher.
See, this you are referring to, it shows rifleman
Rifleman to
to Havildar,
Havaldar.
right? So it says cipher CL3.
Class 3.
Huh?
Class 3.
Class 3,
Class
okay.
3.
Eligible for promotion to
To
Havildar.
Havaldar.
So which means that your rank is now below Havildar as a warrant officer.
No, this, we are talking about a pass, my lord. As
Ah.
of now, we have subsequently we have attained the rank of warrant officer. But then the remonstration that happened earlier, my lord, it has been wrongly, the date has been wrongly fixed.
From Havildar, you have been further promoted to warrant officer.
Officer. So I'd actually want my friend to respond on this basically, because this clarification clearly shows that upon passing of that particular exam, you are to be remastered, and we are given duties.
Where
Of-
is that specification that you have to pass an exam and it says class 3
My lord.
eligible for promotion on remarstration.
on remarstration.
Now, what are the procedures or rules available for remarstration?
No, that is in the writ petition, my lord, I'm submitting to that.
Reply. Page 29 of our reply, my lord, it is there. The rules, the recruitment rules, my lord.
Your affidavit.
Affidavit.
Yes.
My lord can see, my lord, page 29, serial number 36, Havaldar cipher. Now the qualifications are on the right side. By considering members of Assam Rifles holding the rank of rifleman in the trade of operator radio and line with 8 years service in the grade and have passed map reading standard 2, cipher class 3 and N cadre. Medical category must be AYE except for low medical categories. So, my lord, those riflemen in the rank of operator radio line will have to have the service of 8 years to get the promotion of Havaldar cipher, which, my lord, according to us, they did not fulfill that criteria.
Sorry, I'm not following what you're saying.
No.
Come again?
My lord, for being qualified or getting promoted as Havaldar cipher, a personnel has to be, my lord, radio
So
operator
first, let
line.
us understand
For-
that
yes.
ciphers, say, your original entry was as a rifleman.
As a rifleman, ORL,
ORL.
What is ORN?
operator radio line.
Radio man, okay. From there, the next line of promotion is
In-
cipher.
No, my lord, in ORL is a different rate. ORL will go to the next stage of Havaldar, Havaldar ORL, Warrant Officer ORL, Subedar ORL. That is a different rate
The
altogether.
post of a cipher is equivalent to which post?
Cipher, the
In the
initial
either
rank is,
Or
for
the pay
ciphers,
scale?
my lord, the cipher initial rank is Havaldar. There's no rifleman cipher. It's a Havaldar cipher is the initial rank, and that initial rank and post is filled up by remonstration from ORL.
ORL.
ORL people, once they pass a particular exam of map reading and the skill test and this NCADR, they are remonstrated into ciphers. Now the RR says, my lord, which comes in 2002, it says that in addition to this, you need to have 8 years experience as a ORL. Now, the two ROIs that we have produced otherwise have clarified this particular point that this 8 years can be overlooked because the cipher threat, if there is a vacancy, the moment you pass the cipher, sorry, this particular test, you are to be given and assigned the duty of cipher because otherwise there will be vacancies in cipher and it will cause operational difficulties, my lord.
So you pass
So-
the exam, then you are remastered as ciphers,
We were, my lord, given duties as ciphers, but then we
no pay scale.
were given, my lord, the actual rank and pay only from 2007, my lord, when we completed 8 years.
You completed
8 years.
8 years. And you are seeking this from which?
We want to say that from the date of passing NCADR, which is the date we were actually assigned the duties of
Where is your
ciphers.
order for remastration?
My lord, that is there in the petition, my lord. Come back. Administration process. Initial dosage frustration. 2002. Allowed to come back to page 48, my lord. In fact, the specific orders are not there, my lord. The statement of passing of NCADR and date of my lord actual assignment of duties is there.
48.
My lord, para 12, lordship would come to first. 16. Page 16. Page 16, para 12.
Yes.
I've given a chart.
So with effect from these
These
dates,
dates, we were actually assigned the duties of cipher.
you were?
We were assigned duties of Havaldar cipher. But then the actual benefit was given to us as per my lord impugned order at Annex 15. The date of remonstration was taken as 18/6/2008.
Annexure 15.
15.
And what
18/6,
is-
2000, page 73, my lord.
7.
Sorry, 75.
75.
Page 75. There's actually a history behind this, actually. This 2019 order, why this came at this stage, is that because this entire trade was restructured and MSCP, ACP benefits, which were earlier not given, were now to be taken into account. Therefore, these dates of remonstration and assumption of a particular post had become vital. So this was done in terms of some orders passed by this court and Meghalaya High Court, which was upheld by the Supreme Court, and the entire trade and their dates were restructured. While restructuring, my lord, and putting up these different dates, for this particular persons, this date was taken as 2008. Therefore, they lose out their first ACP benefit, my lord. That is basically our grievance.
So someone approached the Meghalaya High Court.
My lord, the Meghalaya High Court order was basically as far as grant of ACP and MSCP benefits are concerned. Therefore, my lord, these dates were taken into consideration again. But then while refixing it, my lord, this remonstration date has been taken as 18/6/2008 for this particular petitioners, whereas we,
No, but yes, what is the stand of the respondents here?
My lord,
I'll just sum up basically. These dates are otherwise, I believe, not in dispute. The core issue now is that they say that the recruitment rule says that it is 8 years, and since you have not done 8 years, we are taking the date after you have completed 8 years of service.
That's what we want to see.
My lord.
What are the requirements for being a cipher?
That is there in the recruitment rule otherwise, my lord. It is passing of this class 3 and cadre test basically. ORL has to pass this
So
class 3 test.
What is the issue about 8 years?
It also says, recruitment rules also says that ORL who has completed 8 years and has passed this trade test can be remonstrated into ciphers. Now,
So
8
before
years
eight-
has become,
Before 8 years, if you pass this exam,
my lord.
not eligible.
you're not remonstrated.
We were remonstrated basically, but then we were not given the benefit, though we were
You did not-
assigned.
you did
We
not
were
com-
assigned the duties of cipher.
But you did not complete 8 years.
At that point, we did not. There's no dispute on that also. And to support our case, we have indicated that the ROIs that they had issued, my lord, even prior to the
What are
RR,
ROIs?
that record of instructions. These are executive instructions, my lord, supplementing the rules. The rules have been supplemented and clarified by the two ROIs. That is why I pointed out this page 244. 244 says that you can, upon passing of, as far as cipher is concerned, there is a star mark, an asterisk. Though it is 8 years is mentioned, upon passing of this class test, ciphers are to be remonstrated, my lord. The reason being,
Where are the orders, Mr.
My lord,
Gupta? Where are the orders giving them the appointment as ciphers, initial orders?
my lord, those orders have not been annexed, my lord, but the date of remonstration is not disputed. My lord,
What are you disputing?
my lord, to be eligible, my lord, on remonstration, the qualification has to be fulfilled. The rule
What is
which
that
I have
qualification?
just,
What is that qualification?
the minimum 8 year service
Therefore, we
as,
want to see the original order of appointment.
my lord,
They have not enclosed, you must be having it in your records.
yes. My lord.
Why are you shying away from producing it?
No, Lord, we have stated it, my lord, that is not in dispute. That the date of remonstration,
We are not,
my lord,
we are not asking you to clarify on the date. We
No,
want
no.
to see what is stated in the order of appointment.
my lord, I can produce, my lord, in that case, I'll produce it, my lord. The appointment letters will,
right, and page 96 of that affidavit, they have given a corresponding charge.
Was it additional charge or was it a regular appointment?
It was a regular appointment, my lord.
If it is a regular appointment, then you appointed them.
yes,
They are entitled to the pay and the grade.
Hello.
that aspect, my lord, I'll have to
That is the
clarify.
core issue only.
So it is their contention, my lord, that they have been given Havaldar cipher prior to the actual, my lord, date of entitlement. But our contention is that, my lord, they have not fulfilled the
You
criteria of
have-
minimum
do
8
you-
years.
Do you dispute their contention that from X date they were allowed to work as ciphers? Is
Yes,
there a dispute with regard to the dates? No.
no, my lord.
The dispute is in what capacity they were allowed to
Yes,
work.
yes, my lord.
For that, don't you think the initial orders of
Yes,
appointment are
yes,
necessary?
yes, I'll produce in that case. In fact, that stand has come, my lord, subsequently by
I think that will be necessary.
My lord, my lord.
affidavit.
And also the clarification on the point that the ROI that has been issued in 2002 after the RR it clearly says that it is after passing of this
Let us have
test.
the benefit of you're not producing your appointment orders. They're not producing your appointment orders. And both of, you're arguing on the rules.
My lord.
You have to first explain to us what is, in what capacity were you appointed or promoted or upgraded, whatever term you want to use.
My lord.
Day after,
Day after, my lord, some time, my lord.
heard Mr. B. Pathak, counsel for the petitioner, and Mr. H. Gupta, learned CGC. The dispute in the present writ petition is with regard to the grant of the prescribed scale of pay to Havaldar ciphers, 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 to which the writ petitioners claim to have been appointed / allowed to work with effect from their individual dates, as is mentioned in para 12.
Para 12, and they have also reiterated that chart at para 8 of their affidavit, my lord.
We are going by your submissions as per para 12 in the writ petition. So the grievance of the writ petitioners are that the scale of pay has been granted to them only after 8 years of such services. At present, they are serving as warrant officers. In which force?
Assam,
The Assam Rifles. So the claim of the writ petitioner is the grant of scale of pay with effect from the date they were initially allowed to work or appointed as Havaldar ciphers. Stop. Although the dates of appointment have been indicated in the writ petition and subsequent dates for promotion to the next higher post of warrant officers, as well as the dates from which they are allowed or given the pay scale of Havaldar ciphers. However, the initial orders of appointment or engagement to serve as Havaldar ciphers where initial appointment of the writ petitioner is not part of the pleadings. Mr. H. Gupta, learned CGC, is permitted to produce such orders to reflect the capacity in which the writ petitioners are permitted to place such orders from the records before the court by the next date fixed. These orders may be necessary to decide on the question as to in what capacity the writ petitioners were initially allowed to work or be engaged as Havaldar ciphers. List again, as agreed to, list again on 18th November. Sorry. 20 November. 20. Public.
Items 4 and 5.
May please, your lordship.
Yes.
Lordship, even last occasion, Lordship, the instruction was sought for from the Department Lordship Board. And according to the this last occasion, Lordship, before vacation, it was listed, Lordship, and my learned colleague was, Lordship, considered with a prayer of this petitioner to, Lordship, upgrade them to the regular post. So on that day, Lordship, because of positive time, Lordship, no order could be passed, Lordship, and now, Lordship, so only under the grounds that, Lordship, they were appointed under temporary Khalasi or Khalasi officers, instead of, Lordship, appointing them as a regular employee. That
What
is
is your prayer? What is your grievance here?
Yes, only to upgrade, Lordship.
Only to
upgrade to the regular post loss.
Upgrade.
Loss.
The petitioner were Malad appointed on compassionate ground, shown as appointed on compassionate ground, but they are not against regular vacant post. They are praying before your lordships that their post should be regularized. As per office
How
memorandum,
can you appoint in compassionate?
that is the one, the compassionate ground, temporary appointment cannot be given.
Then how has it been done?
And one petitioner is Malad, when the father was died, Malad, he says she was only 8 years. And that was also appointed after a long time. That cannot be done, Manoj.
Then
So
according to
regulation was rejected by the finance department. So finance department is not made party here.
No, Lordship.
So which department has engaged them?
Lordship,
Where have you been engaged?
Water sewage department also.
Huh?
Department of Housing and Urban Affairs Lordship.
Where are your appointment orders?
Lordship. The first appointment Lordship will find at page 28 in item number 4.
20.
Yes.
But you will see the serial number 15 of
You are in the board. You
board.
are appointed in the board.
Board Lordship.
So why are you saying housing department?
Lordship, because the board is under Lordship, that is why they were made party Lordship. Board is Lordship under this department Lordship.
You are not appearing for the first day before this court.
Lordship.
When we ask you a question, we expect you to give a reply.
Yes.
You know you're appointed under
That
the
is why I'm saying
board.
Lordship, board, I'm saying, that is
Ah.
why first.
So the all appointments made to the board are subject to confirmation
Yes.
by the parent department.
Yeah.
Yes, who's for the parent department? Mr. Sutia.
Malad, I am appealing for the housing and urban affairs department.
That's right. It is the parent department for the board.
Board.
So every appointment made is subject to the sanction to be granted by the department.
Yes.
Is there a set of rules?
Lordship, I have only 2 pages of Lordship instruction from my client Lordship regarding
Not
the,
instructions from your client. You,
is a board Lordship, board
there
instruction.
must be rules.
Lordship.
Where are the rules and regulations?
Lordship, this is Lordship 2 pages is there, Assam Gazetted Extraordinary, January 9th of 1987, and this
You
rule,
furnish a copy properly.
Lordship, with additional affidavit or Lordship.
Huh?
By way of additional affidavit or Lordship, right?
It is up to you how you
Lots.
do it. You want to show, you have to show us what are the rules governing the appointment, recruitment.
Through additional affidavit, not.
Chapter 3 Lordship will find the officers and member of staff of the board.
So is there a resolution of the board?
Lordship,
Where is the resolution?
Lordship will find in my petition also. Lordship.
Where is that?
Yes, Lordship. Proposal of same Lordship will find at page 36.
Hmm?
Page 36 Lordship, the type copy,
33.
36.
36.
Lordship. This was opposed to the Lordship Joint Secretary Government of Assam, Department also have.
Who is for the board?
I'm appealing for the board.
Lordship.
So where are your resolutions?
We have not enacted that particular thing.
We want to see that resolution, bring it on record. Have you
Lordship.
taken a resolution?
Yes, Lordship. The resolution is there, Lordship.
Where is it?
So actually, it has not been
I
annexed.
have the copy Lordship.
Copy is there, but it has not been annexed. That copy was also I'm having.
Lordship will find page 18 Lordship, I have marked it as 18 Lordship.
Yes.
Internal page 8. Result agenda item number 5.
Page number?
Lordship. Page number, Lordship, 18, manually, I migrate 18, Lordship, and internal page 8. Agenda item number 5.
Where are your names?
Lordship,
Agenda item number 5.
item number 5, in between, middle position. May I read the
Article 5, regulate.
regulation of post under compassionate ground in respect of Sri Vinita Kolita Das and Korabi Medhi. Let Padmakanta Das, UD of the board, was appointed as a regular LDA by office order number so and so, and he expired in 2009. Vinita Kolita Das is the wife of late Padmakanta Das, and she had applied for appointment on compassionate ground in regular post, but she was engaged as works as Khalasi on compassionate ground by order number so and so instead of regular post. Her educational qualification is HSSLC. Also, let Sunanda Medhi, regular driver of the board, was appointed 5 order number so and so and expired in 1992. Korabi Medhi, daughter of late Sunanda Medhi, had applied for appointment on compassionate ground dated 2/6/2006 when she reached 18 years age. She was appointed as works as Khalasi 5 order number so and so on compassionate ground instead of regular post. Her educational qualification is BA. Now, Vinita Kolita Das and Korabi Medhi had applied for regularization of service on compassionate grounds, citing that they should have been appointed as a regular employee. As per the government's letter number so and so dated 17/12/21, government has directed to complete the compassionate ground of appointment prior to 2017 by 31st of January 2022. There are 2 numbers of sanctioned vacant posts of regular Khalasi under grade 4 at head office. We may regularize Vinita Kolita Das and Korabi Medhi against those above mentioned sanctioned vacant posts. Proposal has been furnished to the government in this respect by the several correspondence.
Where is the original order of engagement?
Yes, Lordship, in my repetition that is,
Huh?
in my repetition that is well. Page 18, Lordship, the first one.
1/8,
Sorry, page 2/8.
2/8.
Lordship. In item number 4. Then last one, Lordship, say number 15, Korabi Medhi, head office on compassionate ground.
You have accepted this order?
That's true, Lordship, because all Lordship very much aware, all persons are not aware, Lordship, the norms of Lordship compassion.
What
appointment.
about the other
Initially,
persons?
Lordship,
What about the other persons?
She was also the same, Lordship.
No, no, there are 14 persons here, 15 persons here.
Yes, they were Lordship, some master workers, some are subsequently upgraded to Lordship works as Khalasi, but this petitioner was, she applied for compassion ground. And she was also Lordship appointed against her application of compassion ground, not as a master worker upgraded to works as Khalasi.
You are not upgraded.
No, Lordship, I was just appointed as a works as Khalasi.
You were not working as a fixed pay worker.
Fixed pay worker, Lordship, when application was submitted by this petitioner, they were allowed to work as a fixed pay, but thereafter, Lordship, but on a compassion ground only, sir.
The
And-
last page is Lordship lies, kindly see second page. These arrangements shall however not entitle them to have any future
There
claim
is no dispute.
to have regular appointments. So
Yeah.
they have accepted the condition and they have accepted and joining the service.
Yes,
Department has not approved.
you are the creator of all these problems. Why are you sitting silently? Tell us, explain to us how you are
Not
managing
silently,
your
Lordship.
board.
Actually, some anomalies are there, Lordship, because
Ah.
the appointments were made, but this particular clause have been inserted.
How do you intend to restore
Now, the
order
thing is that
within
we
your
have-
board?
We have given the proposal to the government for considering their
No, that will not help you because
Yes,
you are empowered. to-
difficulty is there, Lordship.
Huh?
Only the point is that, Lordship, as per the provision of the act, I'm just referring to the particular provision of the act, Lordship, the managing director.
What act?
Sewerage Board Act, Lordship.
Oh,
The managing director may appoint temporarily for a period of not exceeding 3 months such officers or employees as may, in his opinion, he required for the purpose of this act and the employment of whom for any particular work had not been prohibited by any particular work, had not been prohibited by any resolution of the board. So under with the strength of this particular provision of the act, Lordship, I'll refer to this one, Lordship. I'll submit an details affidavit with regard to that.
Hmm.
On the strength of this particular act, Lordship, these appointments were being made. And subsequently, we have communicated to the government for considering the case of the petitioner, because actually they were appointed on compassionate ground. But while issuing that appointment order, Lordship, this particular this insertion of this particular statement is there, Lordship, that they will not make any future claim. And with regard to that, the communication has been sent to the government for considering the
No, first
stand
thing is
taken by
that
the-
whether the board has adopted the scheme for compassionate appointment.
no, Lordship, there is no such.
Lordship, as per the 15 rules, Lordship, of compassion ground, Lordship, board has the power to, Lordship, appoint a
Appoint.
person on compassion ground of
Hmm.
2015 rules, Lordship.
What 15 rule?
Lordship, I have annexed with my requisition, Lordship. At page number 51, Lordship, you will find. Lordship, just I'm reading, Lordship.
Office
Page, Lordship, 47, starting,
Office memorandum.
office memorandum, Lordship.
Hmm.
Third paragraph, Lordship.
Hmm.
Second paragraph, I'm reading, Lordship, for the purpose of this instructions, the government servants, religious servants
51.
appointed on regular basis and not more, and not one working on daily wages or casual or apprentice on ad hoc or contract or re-employment basis. However,
Come to the paragraph below.
yes, autonomous bodies, institutions including municipal corporations, cooperative institutions, universities, etc., under the control of the government may adopt this policy or formulate such policies for compassionate appointment in their services under
So has it been adopted by the board?
that lawsuit department will
Not-
very much wait.
Then how can you make compassionate appointment? On what provisions?
Because if your Lordship kindly see the prayer that has been made before the government, I'm just referring to the communication.
Lordship, if I see the impugn order, whoever lordship their claim was rejected by the government, lordship will kindly have the
Right,
impugn order at page 40,
Please?
40. They have cited a notification, lordship, which is not at all applicable with regards to the petitioner's laws. Page 40, lordship will find.
Hmm.
It was written to the joint secretary, lordship. I am just.
Where is the
reading again.
notification? Where is the notification?
Notification also I have an clause.
the last page.
Notification, lordship will find starting from page 43. Page 41. This type copy, lordship. This notification, lordship will find the subject, regularization of service of workers, master role, and similarly placed workers engaged prior to 1993 and continuous service since engagement. This notification is not lordship regarding compassion appointment. And this will not be applicable lordship regarding this case of the petitioner.
No, you are harping on compassionate appointment, but
Yes.
you are an employee under the board. Whether the board has adopted this scheme. This is under a scheme, this is not under an act.
Yes. But since lordship,
Merely because somebody has used the word of compassionate appointment,
yeah,
doesn't mean that
Lordship.
you are appointed under compassionate appointment.
no, yes, whether the board has adopted that policy, that will confirm by the board itself. So we are not aware, lordship, but we just apply for compassion appointment, lordship, because our predecessor were lordship regular employee. So we have the right. to
Your
attend-
predecessor were regular employee, doesn't mean that you will be employed in a compassionate ground
I'm
unless this scheme is
saying-
adopted.
Not saying that, only we have the right, lordship, at that time to apply for.
Where is your right?
To
Under
app-
what scheme?
Because lordship, on compassion ground is, compassion ground says lordship.
The compassionate ground is applicable to government departments.
Government
That
department-
Same scheme, I pointed out to you that para 3,
Yes,
that the autonomous bodies must adopt it.
yes. Lordship, autonomous bodies, institutions, including municipal corporations,
Hmm.
cooperatives, yes, etc., under the control of the government, may adopt. Whether
They adopt
lordship-
it.
Might be lordship they adopted, that is
There
why
is
lordship
no,
they have
there is
appointed.
no, the scheme does not reflect
Yes.
that it must be adopted or it is
It is
applicable.
not, I am not saying that, lordship.
Ah.
They might have lordship adopted, that is
They
why they
might
have.
have
taken,
to-
yes.
Unless you know for certain.
That will be ascertained lordship by this board lordship.
So unless it is ascertained, then how are you urging your right?
Lordship. Because apparently lordship, it is common since their father, yes, that will.
Yes, Mr. Chaudhary.
Lordship, I will get the instruction with regard to that, but so far I know, Lordship, it
22
has.
matter after 3 years.
Yes,
still
Lordship,
in the
3 years
process of
gone,
getting
Lordship, again and again.
instructions.
Lordship, the fact is that the communications, that records that have been provided, Lordship, with regard to this particular record, the communication was there from the managing director. I'm just reading the operative portion of that particular communication, Lordship, that it is to be known at the time authority when they have engaged as work charge instead regular appointment. The compassionate ground of appointment should be in regular post as suitable to the qualification of the candidate applied for appointment on compassionate grounds. Say Binita Korita Das and Korbi Mehdi did not know about the status of regular post and work charge post at the time of joining as work charge employee. While they came to know that their appointment should be made on regular post, they have requested the authority several times to upgrade to the regular post. No fruitful action has been taken. So these communications were there from the side of the managing director lordship to the concerned authority of the Department of Housing and Urban Affairs lordship. So pursuant to that, there is no mention with regard to whether they have adopted the scheme.
That is the first question.
Exactly, lordship. This
Perhaps we should
particular,
have asked whether it is adopted.
because that has not been adopted so far as my information goes, lordship.
Oh.
Then also I will obtain the instruction, lordship may fix it any day in the next week, lordship. This limited instruction with regard to whether it has been adopted or not.
List after 1 week as prayed for by
Lordship may
Mr.
fix
Ed
the date.
Chaudhary, counsel for the Sewerage Board.
Exactly, lordship. That's
To
one number 3. Next
complete
Friday, lordship.
instructions.
Next Friday.
Hmm?
Next Friday.
Next Friday.
One.
How much time do you want?
1 week, lordship. I will obtain the instruction.
Next Friday, all
Next
right,
Friday.
next Friday.
Come on.
Mr. Sovita appears for the general, Mr. Supriya appears for the state.
There's an interim order, so that may be
Interim order passed by the will continue.
lost. Obliged.
Obliged, my lord. Let's say, no.
Yeah.
Right, with your lordship. In this matter, sir, we have filed an affidavit yesterday. Somehow the affidavit has not come to the record.
Mr. R.P. Kakoti, learned senior counsel appearing for the IIT.
IIT lordship.
This is
It will be
the
listed
register.
Tata Convenient Court has said on 11th, lordship.
Submits that an affidavit on behalf of the IIT has been filed yesterday.
Lordship.
So since this affidavit is not available on record, the registry is directed to trace up the affidavit and place it on record.
On-
MSP Borua appears for
For the petitioner.
petitioner.
On
Taken
11th,
after-
lordship.
Lordship is an interim lordship.
Matter be listed again after 2 weeks. Interim order passed on
On
DP
11th, lordship, fix it on 11th.
11th is not possible. You'll have to take a date after that.
After that, lordship, it will more. I know it's possible for me. I'll be away, lordship.
Then we'll have it on December. December,
Lordship, please just, that case.
4th of December,
Lordship.
list on 4th of December. As agreed to by the council. Yes.
Left, lord.
Item 7.
Meet with your lordship.
On the last occasion, I was supposed to file a compilation of the various advertisements and the respective appointments. I have prepared the same. If I may just submit that, lordship. Because the issue here pertains to across 5 advertisements, different timelines, and 8 appointment orders total. So I have just compiled them in a seriatim. Sir, Apunar.
Yes.
My lord, the petitioner before lordship, they are security officers in Oil India Limited,
They are
security officers in the Oil India Limited. In fact, my lord, they were all Group A central government employees, my lord, in the rank of captain onwards. And my lord, after the advertisement was made, my lord, they found it attractive and they filed their application and eventually they were selected and appointed. That is in my lord Group B. Now, my lord, after joining, they find that persons with lesser experience and lesser qualification have been, my lord, inducted to grade C, which is a higher grade. And therefore, this in this writ petition, this claim is made that they should be given the grade C from their date of initial appointment. That is the crux of the matter. Now, my lord, if your lordship kindly comes to the one of the, my lord, offer of appointments of the petitioners, your lordship may find that at page 54.
Yes.
they were appointed between, my lord, 2017 and 2022. As my learned friend has said, my lord, pursuant to the different but similar advertisements, my learned friend wanted to confirm whether the advertisements were same, my lord. That's why that compilation has been, my lord, given to your lordship. Now, my lord, this is an offer of appointment. Congratulations on your selection for appointment in Oil India Limited as security officer in grade B. Now, if your lordship kindly comes to, my lord, an earlier advertisement. Before that, my lord, may I take your lordship to page 103, Annex 11. That is an advertisement. Now, your lordship will find at 103 that, my lord, the group B and group C posts have been advertised. If your lordship kindly sees senior account officer, senior internal auditor, they are in group C. Likewise, my lord, senior medical officer, they are in group C. Now, so far as experience is concerned, there, my lord, against the column post qualification, relevant experience as on 31/4/2017. That, my lord, star post qualification relevant experience in years that has been given, my lord. And so far as security officer is concerned, my lord, there, my lord, your lordship will see against the accounts officer and, my lord, senior medical officer in group C, they are only, my lord, that associate member of ICA, and then, my lord, MD without any experience. So far as security officer is concerned, graduate in any discipline with experience in defense, paramilitary, allied services in the rank of captain, assistant commandant, and DSP. Now, my lord, the discrimination and unreasonableness starts here, my lord. The persons without any experience, my lord, they are in group C, whereas, my lord, the security officer has been put in, my lord, grade B with experience in the, my lord, army. But earlier to it, my lord, if your lordship kindly comes to page earlier, my lord, the security officers were placed in group C.
Group C is higher.
Group C is higher, man. As earlier, if your lordship kindly comes to page
Now,
300,
in the advertisement in question,
my lord,
they were placed under which group?
group B.
Group B.
Group.
At the time when you applied.
Yes,
And at the time when you were appointed also, it is group B.
it was group B.
So why are you putting a challenge? now?
Subsequently, my lord, we have come to know that, my lord, the other persons in, my lord, other disciplines with no experience at all, my lord, they have been placed in group C,
Other means not security.
not security officers.
That's a policy decision. They have decided.
My lord, the policy decision has to be, my lord.
Is it your case that other oil installations, security officers are placed at group?
No, my case before lordship is that, my lord, even in 2010, earlier, my lord, we have placed the, my lord, group C, the security officers in grade C.
No, but you are appointed pursuant to the recruitment process.
True, my lord.
Advertised, where the posts clearly mention that they are in group B.
My lord.
You applied, you are appointed. Now, what is your
Subsequently, my lord,
question? Earlier, it may have been in group C or
my
group
lord,
A, whatever.
subsequently, we have come to know that, my lord, the persons with no experience at all in other disciplines, they have been placed, my lord, in grade C.
It's a decision. How do you want to assail it after you have accepted the offer of appointment, you are appointed? How do you want to assail it now? On what grounds?
My lord, ground put probably is that, my lord.
Is it a case that the Union Ministry has already taken a policy to place these officers of such and such qualification in Group B?
No,
But that has not been carried out by Oil India. It is.
No, that is not the case, my lord. Here is a case where, my lord, so far as their policy is concerned, my lord, they keep on changing from time to time.
They are entitled to.
My lord, in that case, they have to be, my lord, reasonable in that, my lord, and there has not, has to be, my
I'm
lord.
sorry, you'll permit me to have a.
Sorry, my lord.
Yes.
So, my lord, there is no dispute that earlier it was in, my lord, groups, grade C. Subsequently, my lord, they have changed it and they keep on changing, my lord, to their advantage at any point of time. But, my lord, that change of policy has to be, my lord, reasonable. And, my lord, it should not be arbitrary. That is our case, my lord.
Then I think
We have, my lord,
require
we-
some. You'll have to urge on the.
My lord, we are in the army and, my lord,
Parameters of judicial review for policy changes, etc. So it will require, it's not a matter for admission hearing. We'll issue rule, we'll hear it. You can plead your case on that basis. Otherwise, you're appointed, you're working.
we are
And
working.
also promoted now after serving for 4 years.
That is a regular promotion. Some of the
After that,
petitioners
they have
have,
filed this case.
in the meantime, been, my lord, promoted to grade.
Your case is that had you been in group C, you'd have gone higher.
Yes, my lord.
You'd have gone to higher,
In
other higher posts.
In fact, my lord, persons who don't have any experience, so, my lord, they have been given in a better place, my lord. And, my lord, we were, if, even if, my lord, after immediately after.
Have you challenged those, have you arraigned those persons? Or challenged their?
No, my lord,
classification?
because they are from different discipline, my lord.
Then it is your case that security officers, although perform a very vital function, are being downgraded. Or their claims in proper placement has been overlooked.
True, my lord. So,
That's
my
your
lord, in
case.
fact, they have come join this post, my lord, after, my lord, serving as a group A officer in the central government. In the
You
army,
are
my
all
lord. in-
former defense officers.
Yes, my lord. So that is actually, my lord, more humiliating rather than anything else, my lord. That is the precisely the case, my lord. And, my lord, they cannot be arbitrary in, my lord, putting this security officer.
So how are you alleging arbitrariness except by bringing in comparison to say that other persons in other posts or other categories without
Any experience.
adequate or reasonable experience as per your understanding has been given higher.
That is one
Yes.
part, that is one. And earlier, my lord, they placed these security officers in, my lord, grade C. That is a higher grade. These are the two basic points, my lord, on which will be our
We'll issue rule, we'll hear it.
short date. Maybe.
December sometime. Third council for parties, pleadings are exchanged, issue rule. Matter be listed in the month of December.
My lord,
For
a
hearing.
fixed date may be given, my lord. My briefing council will come from outside, my lord. A
Sorry?
fixed date may kindly be given.
All right. You want a fixed date?
Second week of December.
All right. 9th of December?
My lord.
9th of December.
All right.
Yes.
But, now, in this matter, my lord, senior government advocate is appearing, my lord, he is in another court, my lord. Maybe for a timing, my lord, pass over.
Not every time.
We are available till 4:45.
In fact, my lord, I have no file, so my lord.
No. In response to your prayer, we are available till 4:45. Whether your adversary would be available
Yes,
is
yes,
another
yes.
question.
After some times.
After some time.
So there's some urgency because his promotion has been held up.
Is it for?
Lordship had heard the matter, my lord. What had happened, there was
Next higher cadre of IS.
yes.
He is in the zone of consideration, he is not.
All right, we'll take it up.
After some time.
After some time.
Please, Your Lordship. Your Lordship, in this matter, I am led by Senior Counsel Mr. D. Das. Your Lordship, he is out of station. If it is not inconvenient to Your Lordships, can it be taken up on Monday?
Monday.
Yes,
Monday,
Lordship, there's an interim order, kindly that we.
interim order passed will continue
till then, my lord.
till the next date fixed. Monday.
9 and 10 are same, my lord.
9 and 10, all right, Monday.
Deeply approved.
Oh, Monday, sorry, not Monday. We'll have it on. We'll try to have it on 6th.
That's 6th. There are so many cases.
Then,
Let it be 7th or 11th, my lord. 7th?
11th or 7th.
Not 7th, then let it be on 10th. We'll,
Okay,
10th,
okay,
10th of November.
okay.
As agreed to list this matter again on 10th. And the prayer of the council for the petition.
Item 11. 9 money. It will be not my lord, the state has not filed their affidavit.
Yes, Mr. Sutia. This is public health engineering. Who is public health engineering here? Who's for PhD? None appears for the public health engineering. Mr. K. N. Chaudhary, senior counsel, assisted by Mr. D. N. Bhattacharya, appears for the writ petitioner. Although opportunities were granted to the respondents to file their affidavits, the same has not yet been filed. The absence of the councils, matter stands, absence of the council representing the PhD. Yes, PhD, who's there? You are for PhD?
My lord.
What do you have to say here?
That's it.
Yes, my lord. We have already placed the records, my lord. His explanation was, my lord, duly considered and rejected. Now the stage of, my lord, the so-cause comes, my lord. When the petition was filed, my lord, the petitioner was not aware that his explanation was considered, my lord.
Where is that?
That, my lord, finds, my lord. There's a printout of the, my lord, e-file.
Huh?
There is a printout of the e-file, my lord, already in the record, my lord.
Bring it on record.
It's a part of the record. Nowadays, my lord, records are already in electronic form, my lord.
No, this record. Where is
Yes,
it?
my lord.
Is it here?
It's there, my lord, not only in affidavit, my lord, but I have already placed there. I've served copy to the petitioners also, my lord.
My lord, let them file an affidavit, my lord, so that we can also deal with it.
Why don't you bring it on record? We have
That can I do, my lord, but earlier understanding was, my lord, this will suffice, my lord. That's why I have not filed it.
Let us have a look. There was some show cause, then you came before the court interfered, or
Yes.
during the pendency it was withdrawn.
Actually,
Yes.
yes. Then they were withdrawn, then they
Page 10,
again,
my lord. My lord.
then again
Page 10.
issued an explanation.
Huh.
But the explanation was not dealt with properly. My lord, end of the day, I must know why my explanation has been rejected. Otherwise, how do I deal with it, my lord? That is the only procedural safeguards in a decision-making process.
Page 10.
Have you submitted him a copy of the?
Yes, my lord. That,
No, let
that copy I have already
let them
served.
file an affidavit, my lord, so that we can deal with it.
Bring it on record. Short affidavit. Mr. K. N. Chaudhary, assisted by the second part of the again gom pamai. Yat thagibo lage kyu ase tate. Mr. K. N. Chaudhary, senior counsel, assisted by Mr. Bhattacharya for the petitioner, Mr. Goswami, P. N. Goswami, additional Advocate General for the state of Assam, appears for the respondents. On instructions, he submits that
I have the copy of the records, my lord.
he had filed some representation. No, he had replied.
His explanation,
The
reply to his
explanation
explanation.
provided by the petitioner has been rejected. He has placed a copy of that order before the court. However, for the ends of justice, we permit Mr. Goswami to bring the same on record by way of an affidavit.
6th of November, my lord. There is an interim order, my lord.
matter therefore be listed only.
Either 10th or 11th, my lord.
Then
That will be
Yes.
11, my lord, that will be hearing day, my lord, because there is an interim order, this person is returning in February, my lord.
10th or 11th, my lord.
Let it be on 11, my lord.
11th.
11th,
Deep love.
list according.
Matter relates to determination of seniority.
Hmm?
Determination of seniority, my lord.
Seniority.
My lord. My lord, what has happened here, my lord, there's two batches of no, my lord, there were two batches of selection, my lord. The petitioners before your lordship participated in the first batch of selection, and they were successful. They joined on the same date. The issue is that they both this petitioner and respondents, they joined on the same date. And then their seniority, they should have been considered by my lord,
Both are direct recruits.
direct recruitment
Uh,
in the junior.
Same cadre.
Same cadre.
Uh,
The posts which the private respondents are appointed, my lord, these posts when these were advertised subsequently, and at that time when the first advertisement was issued, these posts were not fallen vacant. The post where the private respondent number 4 and 5 had been appointed, those posts had fallen vacant subsequently, my lord, to this advertisement. But there were two separate selection process. But both these respondents and the petitioners, they joined on the same date. Now, my lord, the procedure that was followed by the office was that in such cases, my lord, the select list, I mean, in the gradation list in the cadre was fixed according to the date of birth. That was the practice. Now, suddenly, my lord, they have shifted this practice and now they have put this the private respondent number 4 and 5 above the petitioners, my lord. So that is the issue here in this petition.
What is your claim? What basis are you claiming your seniority?
Because we are the selectees of the first batch. And then according to age also we are senior.
Say,
My lord.
what do the rules say?
Or rules. My lord, either my lord, the age should be the consideration which was followed by the department all through, or else, my lord, I have enclosed a personal department, my lord, office memo, where it is said, my lord, that in case where the direct recruits or promotees, as the case may be belonging to two or more selection panel approved for promotion joint in the same year, then those who have been appointed joined as a result of earlier selection in the panel would be placed senior in the seniority list to those who have been appointed and joined subsequently. So here they joined on the same date, but this panel, I mean, the petitioners appointment and selection was prior to the private respondents. So that way we are claiming our seniority, my lord.
There are two sets of advertisements.
My lord.
You apply to the first set of
First set of,
advertisement.
my lord.
And your selection was also held separately.
Separately. Everything was separate, my lord.
Show us the advertisement.
My lord. Seventeen 2016 was the
Page-
first advertisement, my lord.
Page number.
Page. Annexure A. So can you see?
Page 29,
One second.
29. Written test to result.
Result.
We advertisement no to advertisement no. Nine.
Advertisement is not included.
কি হলো advertisement? Six to 2016 advertisement online
Not included.
to this for information. Final result. Written test results.
The advertisement is not enclosed in this writ petition. Lordship, however, finds it in the writ petition, the connecting writ petition number 2357, my lord. It is at page 15 and 16. Mm,
Item number 20.
mm.
Number 20, item.
The post of junior assistant.
Junior assistant, my lord.
Item number 20.
Two posts were advertised, my lord, by way of that advertisement on 17/1/2016. And out of which one post was reserved for OBC and another was for unreserved category. So both these petitioners, one belonged to OBC category and another in the general category. And thereafter, my lord, their results were declared. Written tests were held on 10/2/2016.
Right.
Yes.
Next one, next.
Yes.
And my lord, the appointment letters were issued, my annexure A and B, my lord, at page.
Let us go step by step. So
My
this is the advertisement.
Advertisement, lordship will find in item
Page
number
number 16 in the second writ petition.
second writ petition.
This is the advertisement in
Advertisement.
which you have applied.
My lord,
The selection procedure is on the basis of written test, practical test, on
Manor.
computer and oral
Manor.
interview.
my
So on which date the selection test and interview was held?
written test on 10/2/2016. Result is annexure A, page 29 of item number 19.
No, don't shift between the matters. Just tell us which writ petition you want to refer to.
Lordship may kindly come to my lord 4876.
All right, 4876. Yes, so 21, 29,
29 is the written test
Result.
results,
result on 10th.
10/2/2016.
Written test result.
Hmm.
This is pertaining to which advertisement?
This 16 advertisement, my lord, 17/1/2016 advertisement.
The dates are not mentioned here.
My lord, date mentioned in this result says 6/2/2016.
Where is the advertisement number in page 16 of the second writ petition? Is the advertisement you have said you apply for?
Right.
Where is the number available? You will take it up after a while if you need some time to correlate.
My lord, maybe taken up the next week, my lord. The first time, my lord, this matter has come to my hand, my lord. I will have to go through both the petition, my lord.
All right.
The industry department.
I'll make a note then in that case, but it will be helpful.
As agreed to, this again next. By the,
Some date, my
by the
lord.
council of the parties.
Wherever-
Well, then if you want a date, then
What's happening? What do I quit?
14th November.
14 November, my lord.
MS,
Obliged.
APS for private respondent,
4 and 5.
4 and 5.
Obliged.
Wait to your worship. Well, this writ petition involves an order of transfer. The petitioner before lordship, my lord, she is a registrar of Labour Court Guwahati,
Registrar of?
Labour Court, my lord. And the private respondent is a registrar of Industrial Tribunal Dibrugarh. And by the impugn order, the petitioner has been sought to be transferred to Dibrugarh, while my lord, the private respondent has been sought to be, my lord, posted in her place at Guwahati. Now, my lord, the pleadings are complete, my lord. And there was an application for vacating the interim order also. In fact, my lord, when the petition was moved on 25/6/2025, my lord, there was an order not to take any coercive action till the next date. Then, my lord, on the next date, that is 30th of June, my lord, the matter came up before your lordship. And your lordship directed that the interim order shall remain in force till in the meantime. Subsequently, on 21st of July, my lord, your lordship has has ordered that the impugn transfer order shall not be given effect to till the next date. But in the meantime, what happened, my lord, although there was an order to continue the interim order on
You were posted in Dibrugarh.
I am in Guwahati now.
In Guwahati, you were sent to Dibrugarh.
Yes, my lord. And during that, my lord, in the interregnum when the interim order was enforced, my lord, the private respondent was allowed to join, my lord. Although in view of the order of this court, my lord, the transfer order ought to have been, my lord, suspended or withdrawn by them. Instead, my lord, they have allowed the private respondent to join. Now, my lord, the government has also filed an affidavit taking their stand, my lord, that it is in the public interest. My case is that, my lord.
Public interest.
Yes, my lord. Although
By allowing the order to be implemented during the currency of a stay order.
No, my lord, they said that the transfer order is, my lord, in the public interest, although they also say that it has been.
Who's for the government?
Your
On the
lordship, I
record.
appear. I appear, your lordship.
So
Your lordship,
why you violated the interim order?
Your lordship, let my senior complete, I'll get to that particular point, your lordship. But there is no violation as such. There's no violation.
No, on merits will come, but let us understand on which date you allowed them to join.
That is on, my lord, 7th of July 2025. That
Your
your
lordship,
7th of July, the interim order was already in force.
your lordship, if I may state, your lordship, there is no interim order on 25th. They just gave an undertaking on the basis of one OM.
What is an undertaking?
Undertaking that no coercive action on 25/6. No coercive action will be taken against the petitioner because as per this OM which I have annexed in my affidavit in opposition, which actually came out in 2024, as per that particular OM, if a transferred employee doesn't join.
Let us understand the facts. We'll go to your OMs and
Yes.
replies and notifications.
Yes,
On 25/6,
yes,
there was an undertaking or an assurance that
Assurance.
no coercive action
no coercive action.
till the next day.
Yes.
So on that day, you are still in Guwahati.
yes, ma'am.
All right.
I'm
Then
still
on
in Guwahati.
36, interim order was extended till 21/7.
That interim order was only with regard to coercive action being taken against the coercive action. The disciplinary action will not be taken against the petitioner because as per the OM in force,
We don't know what coercive action. It says
Because-
coercive action. What is a coercive
the
action?
records will actually show that in fact, if he doesn't join, then disciplinary action will be taken against the petitioner. That
Hmm.
will not be taken. That was the assurance that I gave before the court.
We don't know what the order reflects no coercive action.
Yes.
Whether
but
it
there's no
amounts
stay.
to, whether it amounts to ex parte unilateral handing or taking over of charges,
Yeah.
whether it amounts to disciplinary proceedings, it is not reflected in the
Yes.
order.
Your
Order
Lordship,
merely says no coercive action.
that order also doesn't reflect anything with regards to stay of the interim order. The interim order was granted only on 21/7 after the court reopened after the vacations on 21/7. Your lordship stayed the effect of the transfer order. Now, before that order was passed, before 21/7 itself, the private respondent had joined. And
When were you posted with that information?
I was posted with that information after 21/7,
Hmm.
Your Lordship.
So
I
once that
received
order
the
has been
instructions
passed,
1st of
assuming-
August.
Assuming there is no interim order, earlier order has been passed on 21/7.
Yes.
What steps the department has taken?
Your Lordship, we filed affidavit. In the meantime, the private respondent filed a IA for vacating of the interim order. And
Right,
in that IA, Your Lordship, a status quo order was
we
passed.
find that there is a willful attempt to circumvent the interim orders passed by the court.
Your Lordship, there was
Besides
no,
the department, we are now also wondering what to do with the council because we have given an assurance to the court.
Your Lordship, I had only given
We
assurance.
don't know, Mr. Counsel.
Your
Your
Lordship-
assurance is reflected here, whether this assurance will cover the entire effect, partial effect.
Your Lordship,
You ought to have got a clarification.
Your Lordship, only with. regard-
Firstly, we are nobody to advise you, but firstly, you ought not to have given an assurance.
Your Lordship, I never gave an assurance as
No,
such.
but you did not recall this order. This
Lordship-
order clearly reflects with the assurance that no coercive action will be taken. Who has given this assurance?
Lordship, actually what happened, my learned senior counsel was also present on court on 25th of June, just before the vacations. In fact, that statement was also never made, but that was recorded, but what can I say, Your Lordship?
Contempt.
Only with regards to that issue, that no disciplinary proceeding will be taken against the petitioner. Your Lordship.
Register as on decisions presenting officer. Not a party. Who's for the department here?
Your Lordship, I appear for the Labor Department. here.
You appear for the labor department.
Yes, Your Lordship.
Assurance given to a court not followed up amounts to a contempt.
Your Lordship, I gave an assurance only with regards
We are
to,
not disbelieving you even for a second, but we have to go by what is there available in the order.
Your Lordship, I agree.
Then
Coercive
if you
action-
agree, then
Your Lordship, coercive action only with regards to disciplinary action not
that
being
is
taken.
your
against the
explanation,
petitioner.
Mr. Counsel. This explanation is not relevant is not seen in the order. If you had that understanding of the order, perhaps you should have got a clarification.
Your Lordship, that.
Number one,
I'll file
number
an
one.
IA then.
All right,
seeking
we'll
clarification.
give the benefit of doubt to you. Number one. Number two, with effect from 21st of July, you admit that there is an interim order and that information that the person has joined later. Was it brought to the notice that prior to the interim order,
No.
the person has joined?
I received those instruction on 1st of August. Your Lordship.
So what steps did you take to bring it to the notice of the court that this interim order needs to be modified, recalled, vacated?
Your Lordship, in the meantime,
Yeah.
this IA was filed by the private respondent and that matter was heard. And I placed those records before your Lordships in the IA itself. Since that IA was pending, which was filed, that we did not feel the need to file an IA separately, clarifying this issue. This was actually
See,
decided.
you are first an officer of the court.
Yes, Your Lordship.
You are first an officer of the court. It is one of your bounden responsibilities to ensure that the majesty of the court is not soiled. Now, if you are a party, however partial it may be, to that attempt, you're equally exposing yourself to contempt.
Your Lordship, on 21st, I was not aware of that particular instruction that the private respondent had joined, Your Lordship.
When
Since
were you aware?
I became aware on 1st of August.
1st of August.
1st of
So
August.
what steps did you take from 1st of August in view of this order
Your
that this
Lordship,
person has already joined? Did you bring it to the notice of the court that on the
we
day
filed
when
the
the interim
counter
order was
affidavit.
passed, the person had already joined, so this interim order may be recalled or a clarificatory order may be issued?
Your
This
Lordship,
is not a status quo order.
immediately, Your Lordship, in the meantime, the private respondent filed an I. In the I itself, the status quo order was passed, that interim order was modified, Your Lordship. The 21st of July order was modified, Your Lordship. And
Where is that order?
it was passed in the IA, Your Lordship, IA number 2985 of 2025.
What is the effect of the order?
Your Lordship, in that order, if I may just have to go through that order, Your Lordship.
It's changed to status quo.
Status quo. So that itself, when liberty was granted to us to file an affidavit bringing this particular issue on record, that the private respondent had joined prior to the passage of the 21st order, 21st July order. So we brought that on record by way of a counter affidavit in this matter, Lordship.
Counter affidavit filed on 13th of October.
13th of October, after the order passed in the IA.
Now, my lord, the private respondent and the, my lord, department, they are hand in glove, my lord, which is also fortified from the fact that, my lord, the averments in the IA.
No, if they are hand in glove, you should have pointed out before the court that in spite of the interim orders, they have joined.
Your Lordship, I
I have pointed it out,
that
my lord.
particular
I have
issue,
filed
Your
the
Lordship.
objection in
of
the IA.
handing glove.
How can they say?
I say because the averments are similar. In fact, my lord, the
Maybe.
ad verbatim, my lord, quoted from the IA, that finds place in the, my lord, affidavit of the government. Your lordship may kindly see their affidavit, my lord, these
Your
two
Lordship, if we should,
affidavits.
I think we should not divert from the main issue in hand, which is, in my humble submission,
No, how they
we
are
should
trying
be
to
on the
steal this
merits of
matter.
the case, Your Lordship, instead of going to hands in gloves. And on this issue, the issue here pertains to a transfer order. And in my respectful submission, Your Lordship, this transfer order is good and it was done in public interest. And Your Lordship had actually inquired as to how request transfer initiated at the request of a particular individual is not a private interest and not and how it is a public interest. That issue was clarified in our counter affidavit, Your Lordship. So instead of going into the issue of diverting from the issue
No,
in
it
hand,
is
Your
not
Lordship,
everything. I am showing
because
favor in
the
hand
main
in glove.
issue is
Same
how it
paragraph,
is private
same
interest and
statements
how
were
it
made.
is not public interest.
Same
That
statements
is what
which
I
are
have to
made in
clarify.
IA. Those are, my lord, quoted in, my lord, in the affidavit in opposition, my lord. I can show your lordship. Now, the, my lord, the attempt they are trying to make and protect the, my lord, the private respondent, they want to say that, my lord, an application, a transfer on request is in the public interest.
Who's appearing for the private respondent?
Lordship, I have filed a vacation order by IA Lordship. In my IA, I have annexed all the documents of my own. I have not annexed any document of government Lordship. This is all my joining report, everything. When I was joined, everything, when the everything Lordship had kindly go through all the my sub annexes. Because I have handed over the chart on page 16, Lordship, of my IA.
Which IA?
985.
2985.
How they can say I have handed my envelope with a government lordship? This is my own document. I have not annexed any government document.
I am talking about Evermins.
Everments. This is everments or submission. Lordship, kindly see page 16. And the petitioner, she is staying in Guwahati for more than 13 years. So I'm going to retire after 1 year and 2 months, Lordship. This is my last leg posting.
How does it matter to you whether you want to come to Guwahati?
No, because my original home is at Nagaon, Lordship.
Hmm.
So my ailing, see, they have taken the ground that their daughter is going to appear in the LLB examination.
No.
But my son is
You
also.
made a submission that they're saying for 12 years or 13 years or whatever. How does it matter to you? Because you are also being transferred out.
Now, every 3 years, also, the government officer is to be transferred.
So that is the justification we'll hear from the state. You are for the private respondent. Is
Yes.
it a transfer on own request?
It is.
It's a transfer on.
I given a, because it is my last leg posting, Lordship.
You want to be in Guwahati.
No, I just want to stay in Guwahati for more than 1 and 2 months because my ailing ground is my ailing mother. She is 85 years old.
I do not make the submission that, my lord, her request should not be, my lord, considered. What I am on is that, my lord, a request transfer is not, my lord, transfer on public interest. And if you have to consider, you have to consider the, my lord, comparative difficulties of the other persons also. My difficulty was not considered. There are other posts in Guwahati where he could have been appointed. Those are not considered.
What is the MLFID? What is the malice?
That is, there lies the malice, my lord.
What
You
malice?
consider the representation of one person on request, you consider, that is fine. But while considering, you have to consider the comparative difficulties of the other employees also.
No orders are passed in your representation.
My lord, no order has been passed. In fact, my lord,
Where
they
is
cannot,
your representation?
they cannot give a color to of the public interest in a request transfer.
Where
That
is
is
your
Supreme Court is very
representation?
clear, my lord. Page 14, my lord. Page 14 of the petition.
Page 14.
My lord.
What do you say regarding this representation, government?
Your Lordship, here in the records are there. In with regards to the representation, this order was passed on 26/2024 and 25. And with regards to the representation, on 21 itself, they observed that their reputation, this representation of the petitioner is pending. So we will consider the representation. Just that disciplinary action may not be taken against her for not joining in a place of posting without leave of the department. Here, if I may
The
produce the,
representation is for transferring, reconsideration of transferring.
yes.
What
That-
orders have you passed?
That is, they have actually, the petitioner has submitted a representation on 26 itself. And if I may produce the records, Your Lordship, the records are very much clear as to the decision-making process.
Hmm?
This is the office note, the e-file. And the next page.
What is the?
Next page, Your Lordship.
Hmm?
Flag E.
What is the decision?
We could not actually, because he approached this on the court, we could not take the decision, Your Lordship.
That is what we are asking you. You are saying some decision is taken.
No, Your Lordship, we were about to take a decision, but before that, she approached, since the matter became sub judice, we could not take any decision. Also in this regard, Your Lordship, with regards to the submissions being made by my learned senior counsel, Your Lordship, I'll just like to place one particular judgment of the Honorable Supreme Court, wherein this transfer at the request of any particular person would not be considered to be a private interest. Your Lordship. If I may just place this judgment, this is a very short judgment of 2 pages, Your Lordship, just 2 paragraphs, Your Lordship. Because the Honorable Supreme Court has said in transfer matters, employer is the best judge. And even in cases where transfers are initiated at the request of any private.
What is your prayer now, Mr.
My
Chaudhary?
lord, my submission will be, my lord. Since, my lord, the public interest and my lord, the request on transfer, my lord, they cannot be on the same footing, my lord.
On what basis are you making this statement?
My lord, this I am making on the basis of a decision of the Honorable Supreme Court, my lord. May I please that decision, my lord? But it is said, my lord.
What is your prayer?
Now, my lord, I want that this order has to be set aside and the matter has to go back to them. The comparative merits and my lord.
Why the order has to be set aside? We can
Because-
direct them to consider. your
because this is
application,
not
file
in-
necessary.
Because this is not in the, my lord, public interest.
Hmm.
It is on the request of the, my lord, private respondent. And therefore, my representation should also be
If it is
considered.
not in public interest, if we are satisfied, we'll interfere with it.
My lord.
There is no question of remanding the matter back. You are saying interfere and remand. Why should we interfere if we have to remand it?
No, my lord, if your lordship interferes and sets aside that order, my lord, that is the end of the matter.
Ah,
That is the end of the matter.
so what is your prayer now?
Your lordship will set aside that order, my lord.
Right, so we'll hear you on this. Heard counsel for parties, matter stands referred to be listed on 13th November. Matter to be treated as part of. Yes.
Okay.
Your Lordship, can I get back the record?
Yes, take it back. Record us.
My lord, before the other side begins, matter was heard at length on last occasion. Can I take 5 minutes, my lord?
Yes.
So whole case is, my lord, that sub-registry office, Mukalmua, was established in
You were
1980
appointed on commission basis by the sub-registrar.
by the sub-registry.
Subsequently, the sub-registrar's appointment was regular,
Regularized, ratified
ratified.
without any sense.
And the direction of the court was that the entire establishment is to be ratified.
Ratified.
So since you are a part of the establishment, you are praying for
That establishment is permitted by this Assam registration manual.
Assam.
Although Assam registration manual, I have filed additional affidavit, my lord. Kindly additional affidavit filed on 2023-25. And argument was also filed. It is in the written argument. That part. The written argument submission was filed on
Additional affidavit
additional affidavit.
filed on
Filed on 2023-2025. So, what dispute they have arised after the matter has attained finality?
one minute. Additional affidavit filed on
2023/25. Kindly see page 83, my lord.
wait.
Para 3.
83.
Yes,
83.
running page 83. Our additional affidavit, my lord.
Okay. Yes.
Para 3, my lord, that the deponent begs to state that so far as the present case is squarely covered by the judgment and order dated 12/5/2023, passed by the division bench in writ appeal 73/2019, the state of Assam versus Mohammad Hussain Ali. There is no dispute that commission basis sub-registry office at Mukalma was sanctioned in the then Kamrup district by notification dated 28 February 1984 by the Registration Department, Government of Assam. There is also no dispute that the government of Assam Registration Department had notification dated 28 April 1984 appointed Juan Muhammad Hussain Ali as sub-registrar on commission basis in accordance with the instruction and orders contained in the registration manual, Assam registration manual, my lord. That I have further uh, filed in our argument, written argument. This newly second part, which they are harping on, that how now after 24 years of service, my lord, entire establishment was regularized by taking a cabinet decision in the year 2007 and regularization 2008. At this juncture, when I shortfall 10 years regular service, and that was the issue before the single bench and division bench upheld it. If my entry point was illegal, my lord, why they regularized my service? That means my past service was counted, my past 24 years of service. If I was not in a substantive post, I will refer to Dolly Borbojari's judgment, my lord, that division bench judgment. We are relying, division bench also relied their judgment. If I only Hassan Ali could have been regularized, why the other staff? Why the remaining 6 persons? So I was working in a substantive post. Right now they cannot
Where is the
question.
order? Where is the order subsequently?
Subsequent that regularization order.
Yes.
That is in writ petition, my lord.
Yes.
Annexure page 39, my lord. Annexure 6.
39.
What is the fault with this order? That question of issue estoppel, my lord, entire issue was has attained finality. They could have gone to apex court again when division bench, after remanded back by apex court, dismissed state's appeal. Now they are in a similarly situated cases. I am similarly situated because Assam registration manual itself in the establishment there is clerical post. How a sub-registrar can work without clerk? In the interest of public service and as per cabinet decision dated 5/7/2007, the governor of Assam is pleased to regularize the services of following employees of the
You are reading
Mukalma.
from page number?
Page number 39, my lord, Annexure 6, of the writ
39.
petition.
Okay.
May I read, my lord?
What is that 38?
38 is that cabinet decision, Annexure 5. And rule I have also enclosed, annexed. Commission system will cease. That is Annexure 5, page 38, Mukalmua. But regularization order is in page 39, Annexure 6.
What is your name?
My name is Siddiq Ali, number 2. Muhammad Hussain Ali, sub-registrar, sanction letter. So I am, writ petitioner is Muhammad Siddiq Ali, LD assistant.
AC to low.
There are 2 LDs and registration manual permits. How many LD will be there? This is their order rule. Number, that depends upon the number of cell dates executed. Undertaking that dispute also is over. Hussain Ali also give undertaking. Otherwise, they are not paying our salary. That undertaking could not take away my fundamental right to pension. That part is also decided.
So you have been regularized with effect from the date.
With all manners.
Huh. So
Because, my lord, there is one thing more. According to their own service rule, a commission basis sub-registry office should have been regularized after 8 years. That means entire office was to be regularized as per their own service rule in 1992. It is a delayed regularization. That's why shortfall of my regular service. That's why we are before your lordship.
he is now under the new pension rules,
How can it be?
but with no contribution.
Contribution he has made.
He is
But,
made-
I have not taken it back. I have given statement.
Taken
Why
it
I
back?
take? Because
Taken it
without
back is a-
contribution, they are not paying my salary.
Whatever it is, you have contributed, you have opted
Oh,
for it.
no. But when Hussain Ali got it, I filed a representation. They did not reply it. Thereafter, I filed this repetition.
All right, all right.
I'm other.
It
If I
will pass
don't
on this, we
contribute-
have heard.
If I do not contribute, they would not have paid my salary, my lord. That is the whole difficulty. That part is also over. Hussain Ali also paid. It is their document.
That example.
Everybody's name is there. Everybody paid. This is their
My
own
lord, yes.
document.
My lord, one judgment, my lord, I will be placing, my lord, of course, my lord, I will not deliberate upon it right now, my lord, that the decision of the coordinate bench of this honorable court, my lord, pronounced in the case of Purnima, Hore and others. There, my lord, the entire implications and consequences arising out of new pension rules vis-a-vis, my lord, the old pension rules of
We'll
69.
do it. We'll
Yes, I will
bring it
place-
at 2 p.m.
My lord,
You don't have it now.
my lord, I will be placing it right now along
Yes.
with, my lord, along with my written argument, which I have also.
No,
prepared.
but you have to point out for what purpose you are placing it, if you are placing it in court, because he is entitled to be aware of.
Absolutely, my lord, then I may, my lord, submit on
Ah.
that.
Where is the judgment? Purnima, Hore?
Yes, my lord.
That pensionable, non-pensionable establishment will not come here, my lord, in this case. That part is also decided.
Yes.
My lord, it's a long judgment, my lord, I have given, my lord, the cost title itself, my lord, takes up a lot of pages. But I am relying, my lord, from paragraph 40, my lord.
Mhm.
My lord, it is my written argument itself. Page 65 onwards. I have submitted the written submission. That Purnima Hore judgment. Page 65 onwards. It is on record.
You are reading from para?
Paragraph 40, my lord.
Ah.
My lord, paragraph 40, my lord, to, my lord, para 71. Well, each and every aspect of the matter is, my lord, important. Lordship will, my lord, definitely go through it, my lord.
Hmm.
I need not, my lord, elaborate.
No, you refer to the specific,
Yes, my lord.
each particular from para 40 to 71, you tell us that these are
Yes,
the
yes,
relevant.
yes, absolutely, my
This is
lord.
the ratio of the court.
Yes. Lordship may be pleased to, my lord, to come to para 50, my lord,
50.
50.
At this stage.
More কম, আপুনি ক'ব নালাগে, please.
Yes.
Para 50, my lord. The incidences and consequences of Rule 31 have been, my lord, called out here. Rule 31 of the pension rules, my lord, that is the fundamental provision under which, my lord, a person becomes entitled to receive pension. My lord, the three conditions, preconditions are necessary. Lordship is aware, my lord. Then, my lord, Lordship will kindly see, my lord. Para 51, my lord. My lord, how a person who is appointed, my lord, or regularized after 1/2/2005, that is the cutoff date, my lord. How he will come within the ambit of, my lord, the new pension rules. Then, my lord, para 52.
Hmm.
Because this honorable court has, my lord, taken a cue, my lord, from the decision of the apex court pronounced in the case of Parameswar Nanda, where, my lord, similar situation has arose, my lord. So paragraph 50, 51 and 52, my lord, as well as 53. I am not elaborating, my lord, 53.
Hmm.
Then, my lord, 56, my lord. Para 56.
Where is is there any application order that he has contributed and you have?
Yes, yes,
accepted?
my lord, in the additional affidavit, my lord, filed by the Revenue Department. One additional affidavit, my lord, has been filed, my lord, by the Revenue Department. There also will find it, my lord. Yes. My lord, that starts from running page 138.
138.
Yes, my lord. 138. And more precisely, lordship will find that, my lord, at page 143. It's a part of Annexure A. That is the pay bill, my lord. Pay bill of the rate petitioner.
One. You are referring to one?
My lord, page 143.
143.
Lordship has got it, my lord. Page 143, my lord, down below on the right-hand side, lordship will find deductions.
No, 143 is format in which information is required to be sent by DDO.
Is a part of Annexure A, my lord. Perhaps, my lord, there is some mismatch in the paging, my lord. Annexure A, my lord, to that additional affidavit, my lord. Annexure,
143, establishment bill form.
yes, my lord.
Name of the person is recorded there.
Yes, my lord.
These are the earlier page numbers. Now the new pagination is there.
My lord, my lord,
You compare it and prepare a list and give it to us.
my lord. Now, my lord, in that establishment bill form, lordship will find his name, my lord, Siddiq Ali, name of the government employee. Then, my lord, it is on the left-hand side. On the right-hand side, down below, lordship will kindly see the deductions. Deductions, my lord, General Provident Fund subscription. It is handwritten NPS. It is new pension scheme. Under a new pension scheme, rupees 13,600 has been deducted. Then, my lord, further deductions, lordship will see in the next page, my lord. Kindly see the next page, my lord. Next page. My lord, that column number 32. It starts from column number 22, 23, 24, my lord. The very next page, my lord. Establishment bill form is a continuation, my lord. There, lordship will find, my lord, column number, yes, in column number 32, lordship will see NPS. So these are the deductions.
This
Then-
is a bill of which date?
These are bill of, my lord, of 2014. Yes, November 2014. This is of course one instance, my lord. We have not produced the entire records, but this is an instance, my lord. This has not been, my lord, controverted. He has not disowned, my lord, these documents. Then, my lord, the next page, my lord, lordship will kindly see the next page, my lord. Annexure, my lord. There is Annexure 3. Internal, my lord, this is a part of that documents, my lord. There, lordship will find it on the right-hand corner, my lord, top, NPS. New pension. These are the deductions. And lordship will find his name, my lord. Sixth row, my lord. Siddiq Ali, LDA. How,
Which
my,
page? Which page?
my lord, here, my lord, it is page 145 in my copy, my lord.
145.
My lord.
Yes.
Well, it is something like Annexure 3, my lord, internal Annexure 3. There on the right-hand side, lordship will see, my lord, NPS, top. On the right,
NPS.
NPS. Then lordship will kindly see the table, name of government servant. There, lordship will kindly come to, my lord, the 6th row, my lord, Siddiq Ali.
Yes, this is the amount deducted.
Yes, 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 yes,
This is DA.
yes.
This is not amount deducted. This is DA. Basic pay, DA.
My lord, this is, my lord, it is LDA, my lord.
Then contribution under so and so. I think this is what you are referring to.
Yes, contribution, my lord, under tier 1. 1880, under tier 1. Under tier 1. So he has made his contributions. My lord, this is the fundamental distinction between, my lord, Hussain Ali's judgment and, my lord, the present list. In Hussain Ali's case, my lord, there was not a single finding, my lord, recorded by this honorable court or by the, my lord, honorable division bench to the effect, my lord, that incumbent, that writ petitioner Hussain Ali had tendered, my lord, or, my lord, the government has deducted amounts, my lord, from his salary towards NPS. So for all intent and for all purposes, it was decided that he would be covered under the 1969 rules. That is one aspect of the matter. Second, lordship will kindly see, my lord.
But is there no option required?
My lord.
Is there no option required to be granted? Even
No. So because 1st of February 2005 is the cutoff.
your see, his appointment order or engagement in the service is considered to be in 2008.
2008. It is a fresh appointment. That is what we have said. It is a fresh appointment for all intent and purposes. Why? Why, my lord, I will say so. Lordship will kindly take up the writ petition for a moment, my lord. Heavy reliance has been placed by the writ petitioner on, my lord, the 2010 rules. Because in the year 2008, my lord, their services were regularized. Thereafter, my lord, since there was no service rules pertaining to, my lord, the registration officers, my lord, therefore, my lord, in the year 2010, these service rules have been brought in, my lord. Now kindly see, my lord, the service rules, my lord. That lordship will find at page 40 onwards of the writ petition. His basic case, my lord, emanates from his service rules. It starts from page 40, my lord. Lordship may be pleased, my lord, for the present case, come to, my lord, page 44. Rule 13, my lord.
Yes.
This is, my lord, Assam Registration Service Rules, 2010. Now, Rule 13, my lord, Lordship has got it, my lord.
Yes.
Page 44, my lord. Rule 13, on the left-hand side, my lord, it is written, my lord, selection for appointment to the post of sub-register from departments and on commission basis sub-register. Now, Rule 13, I am reading it, my lord. Subject to suitability as may be decided by the board and by the appointing authority in consultation with the commission, the following persons may be appointed to the cadre of sub-register of the service. A sub-register employed on commission basis who has rendered continuous service on commission basis sub-register for a period of not less than 8 years on the 1st of January, so-and-so, holds a bachelor degree, so-and-so, is below the age of 45 years on the 1st of. So it speaks of sub-register. Sub-register services have been bought under, my lord, the service rules. And how, my lord, a commission basis sub-register can be regularized. Now, here is a
So
case.
now that you have regularized them, they are covered by which rule?
They are now, my lord, they are now covered by the 2010 rules. But here, lordship will find, my lord, why I am drawing lordship attention to this particular rule, because, my lord, provision has been called out here to bring, my lord, commission basis sub-register to the regular cadre if he fulfills these parameters. No such parameter provision is, my lord, incorporated in these rules with respect to, my lord, pertaining to, my lord, LDA or other clerical staffs of the establishment.
No, but are they covered under this rule?
Well, they say, my lord, they are covered under this rules.
No,
My
what
lord.
about you? What does the department say?
Well, that is not, my lord, the list here, my lord. He is trying to clear.
These, you are
Yes.
referring to these rules.
Yes,
According to you, these rules have no indication about LDA,
LDA.
right? But ordinarily, in respect of other departments, it is the ministerial rules which cover.
It is the ministerial
So
rules.
therefore-
Here also it
therefore-
will be, the ministerial rules.
So is there any reference to the persons in the ministerial rules?
No, It is not such. Here, the only reference is made with regard to the post of sub-register. Therefore, my submission is to the effect, my lord, to bring home the contention that if a sub-register is working on commission basis, he can be regularized by dint of this rule, my lord, Rule 13. But if a person is, working on commission basis, not in the capacity of a sub-register, he cannot be regularized by dint of these rules, my lord. Now the petitioner
No,
himself.
he has been regularized. That's
Yes.
what-
Yeah.
Where is the regularization order?
Yes, regularization order will, lordship will find it. Page
Page 13.
39, my lord. Page 39.
You come to the earlier order,
Yes,
page 38.
yes, 38.
38 says,
Commission basis,
Well-
my lord, the entire establishment has been brought into a, my lord, regular cadre.
correct.
Yes,
So entire establishment will mean what?
therefore, if we read, my lord, page 38, what is stated, my lord, here, the governor of Assam is pleased to convert the following 5 existing commission basis sub-registry office into departmental 1 with effect from the date of posting of departmental officers and subordinate staff.
Subordinate.
Yes, the commission system will cease to exist soon after the appointment of the departmental register and subordinate staff for each of the office so converted. So it is in the nature of a fresh appointment. But that argument was of course not accepted, my lord, by this honorable court in the case of Hussain Ali. Because Hussain Ali, my lord, that commission, my lord, appointment of Hussain Ali was done by the government. But here Siddiq Ali, my lord, he is a subordinate officer. He is a subordinate staff who has been appointed by that incumbent, who himself was appointed on commission
No,
basis.
no, then we come to page 39.
Yes, 39, if lordship see 39, my lord, what is the real tenor? In the interest of public service, and as per cabinet decision dated so-and-so, the governor of Assam is pleased to regularize the services of the following employees of so-and-so, converted so-and-so, against the post sanction shown against each of their names with effect from the date of creation of the post. Now, lordship will kindly see, my lord, Hussain Ali, sub-register, Siddiq Ali, LD assistant. On the right-hand side, lordship will kindly see sanction letter and date. So the post is created, regular post is created from 25/4/2008. Lordship will kindly mark this. It doesn't carry any past incidents of service. That is my argument, my. That is my respectful submission. It is explicit, my lord, on the face of the record itself, that this post has been sanctioned and created, my lord, on and from 25/4/2008. So therefore, this is a fresh appointment. And if this is a fresh appointment, my lord, then he will be covered under the new pension rules. Because, my lord, by that time, my lord, the Assam pension rules 1969 has also been amended. And Rule 2A has been inserted, my lord, whereby it has been categorically incorporated in the provisions of law, my lord.
Then why are you giving a regular pension to Hussain Ali?
Hussain
He
Ali-
was also brought with effect from 2008.
No, we were giving, my lord, we had denied Hussain Ali, my lord, regular pension.
That was that
Therefore,
side.
therefore, he approached this honorable court. And finally, my lord, by dint of the order passed by this honorable court, my lord, we have complied it.
No, no, no. You come to the conclusion of the court.
Yes. That lordship will see at page 62,
Page 61,
61, yes.
para 15.
Para 15, yes. In view of the above, and since the finance department is not opposed to examine the case of the petitioner on receipt of proposal from revenue department, the writ petition is disposed of directing the respondents, more particularly the revenue and finance department, to examine the case of the petitioner in the light of the observations made above, and then to pass a speaking order as expeditiously as possible, preferably within so and so. Though this court stopped short of declaring that the service rendered by the petitioner on commission basis should be counted towards the pension, the indication given was quite clear and discernible. Unfortunately, the respondents failed to examine the matter in tune with the letter and spirit of the aforesaid order. This refers to, my lord, another earlier round of litigation, which Hussain Ali led, my lord, whereby, my lord, the authorities has passed a speaking order, and precisely that speaking order was put to challenge here.
So then you read para.
Yes, para 33. Thus, having regard to the discussions made above, claim of the petitioner that the service rendered by him as sub-registrar on commission basis should be included for the purpose of computation of his pensionable service has merit and deserves consideration. Respondents are accordingly directed to count the service rendered by the petitioner as sub-registrar on commission basis prior to his regularization as sub-registrar while computing his pensionable service and thereafter to grant all consequential reliefs. Therefore,
You had filed an appeal was turned down.
turned down by, he had,
To SLP dismissed.
no, my lord, we had initially filed an appeal. My lord, that appeal was dismissed on the ground of delay. We went to the Apex Court remanded the matter, my lord. Finally, the appeal was heard. It was dismissed.
Beyond that, no further SLP.
No further SLP. In the meantime, my lord, that Hussain Ali had laid a contempt before his honorable court, and my lord, finally the contempt was closed. We have, my lord, complied with the direction. That is so far as sub-registrar. Lordship will kindly strike a mark of distinction between the,
You are trying to distinguish,
my lord.
but it appears that the government had already taken a decision to bring the entire the establishment
Yes,
into a regular cadre.
regular cadre.
Subsequently followed up by passing an order of regularization, not only in respect of the sub-registrar, but also in terms of the petitioner and other employees.
No, petitioner and other employees, because whether, my lord, the other employees, the incidence of services of the other employees were at all, my lord, discussed by this honorable court in this decision.
Obviously not,
No.
because they were not before the court.
Yes,
But the ratio of the court is.
no,
that
ratio is applicable with,
ratio is-
yes.
See, the question before the court was
Yes.
whether the earlier services rendered can be counted for pensionable services.
Yes, that is the precise issue.
Right? So the court said that once the decision is taken by the government, they have been brought into a regular establishment.
Yes,
Therefore,
they have been bought, my lord, but
precise word is court stopped short of declaring service rendered by so-and-so should be counted towards.
yes, that is with regard to
That is
my,
in regard to an earlier.
earlier, because, my lord, he had
So
laid
then-
several litigations before,
Then the court said
yes,
service rendered under so-and-so should be included for the purposes of computation of pensionable
Pension, yes.
services. Then it finds
Meaning-
it is
meaning-
not merit.
yes, meaning thereby, my lord, that the past services have been counted. Now, this entire findings is with regard to, my lord, the petitioner who had, my lord, lordship will kindly, my lord, who had been, my lord, initially appointed by the government.
That is irrelevant in view of the subsequent order of regularization.
Regularization, but then lordship will kindly
The
appreciate.
regularization does not say that they will not be entitled to the past services.
No, my lord, his appointment says, my lord, kindly see, my lord, an undertaking. My lord, page 39, kindly see, my lord, page 39 down below. Down below. This regularization order. Page 39 down below, my lord.
What
An
is it?
undertaking, 39 of the writ petition, my lord.
Hmm.
Annexure 6, an undertaking as prescribed in Finance Department circular dated so-and-so must be furnished by each employee to the respective higher authorities immediately without fail.
What is this circular?
My lord, this is with regard to, my lord, new pension, coming into effect of new pension.
Where is that?
But that is not here, my lord. But he has challenged.
Whether he has
undertaking.
given an undertaking.
Yes, my lord, he has
given them. I have brought all the records.
Hmm.
he has given it, my lord, if he,
What about Hussain Ali?
He has also given undertaking.
Hussain Ali, whether he had given any undertaking, my lord, because those records are not before us. But in the honorable, my lord, court's decision, there is no reference to the effect. Whether, no, my lord, whether he had given it, because if a person gives undertaking, only then, my lord, the NPS can be
Tell
deducted.
me one thing,
Yes,
for new pension,
yes.
what is the qualifying service for new pension?
It is, my lord, it's a cutoff date, my lord, 1/2/2005, either this way or that way.
No. Somebody who is prior to, what is the 1/2?
1/2/2005,
So 31/1/2005,
yes,
the person is appointed,
appointed,
is governed by the old pension.
all pension. All pension
So the new pension,
is made effective from 1/2/2005. So coming into the affairs of state, service of the state. Earlier, my lord, he was not in the service of the state, within the affairs of the state.
That is all right.
Yes.
So therefore, Hussain Ali is also under the new pension.
Yes. Hussain Ali
As
also
per
under
the
the new.
department.
Yes, Hussain Ali under, but
So
he challenged it.
He had also given an undertaking.
Yes, my lord, but whether
Most
he,
likely.
whether he has given an undertaking, whether new pension has been deducted, these matters are, my lord, sub silent or in my lord this decision. So I cannot comment. There is no finding, but here I am trying to draw a distinction with this case on these two basic parameters. Number one, my lord, here he has given an undertaking, and since he has given an undertaking,
No. Your, that submission has to be fortified by set of instructions to say that Hussain Ali did not give an undertaking.
yes,
And he has given an undertaking, so therefore they are not permitted.
yes, that may be one aspect of the matter, but my lord, the next leg of my argument will be, my lord, that here in this case, deductions have been made.
So all these, you'll have to show that these are not similar with regard to Hussain Ali from your records at least. That in the case of Hussain Ali, notwithstanding this order, notwithstanding the undertaking granted, no deductions were made, he did not opt for it. Therefore, the court had given a direction. Therefore,
Yes,
this
yes,
case
yes,
on the
yes, yes,
facts
yes, yes.
is
Let me then,
distinguishable.
let us then produce the records, my lord. for us.
You
Yes.
produce it or you
Yes.
place it, but you have to
Yes.
undertake that inquiry first.
Yes, my lord,
This is
definitely.
the
What
repetition,
is
my lord.
this?
Where Hussain Ali gave undertaking, 3551, repetition, part of the record.
We have this copy now. Why are you giving us? You tell us.
No,
the
this
date.
is different, earlier repetition.
Earlier, we're not going to see. Yes, your writ petition is sufficiently voluminous. You want to make it a little more
Yes.
thicker.
My lord, Hussain Ali also given undertaking, that record is there. In
So that
WBC
record you want to
3551.
Bring it on record. You see.
I will file additional.
No. No affidavit is required. They have asked us to examine from the records and give it to us.
Yes, my lord, there is.
Then record
line
of
of
WBC
distinction.
3551 is to be called for.
Huh?
Then record of WBC 3551/2013 is to be called for.
All right. Heard counsel for parties. The question before the court is whether the writ petition
Revenue available.
by petition the 5th of April 2008 issued by the Department of Revenue within bracket Annexure 6, page number 39 of the writ petition. Along with 6 other personnel, including the sub-registrar, 1 MD Hussain Ali. Omar. The petitioner is entitled to be considered and granted the same benefits as was done in the case of MD Hussain Ali, a sub-registrar, pursuant to orders passed by this court in WPC or 3551 of 2013, order dated 2209/2014, which was filed by MD Hussain Ali, lead and sub-registrar. Stop. Learned counsel for the petitioner submits that the judgment of the coordinate bench
Recorded in
was
space.
affirmed- was affirmed by a division bench of this court.
Yeah.
And no further orders or appeals have been placed before the court, which has interfered with the conclusions of the coordinate bench. So it is the submission of the learned counsel to the petitioner that pursuant to the directions issued by this court, the government has considered the case of MD Hussain Ali and released his pension under the old pension scheme by taking into consideration the relevant years of service rendered by MD Hussain Ali. as a sub-registrar on commission basis. So learned counsel for the petitioner therefore submits that the case of the present petitioner is squarely covered, is similarly situated, and is squarely covered by the conclusions arrived at by the coordinate bench in WPC so and so, by order dated so and so. However, the respondent authorities did not accord the same benefit to the petitioner as was done the case of MD Hussain Ali. So petitioner has been shown to be covered by the new pension scheme on the ground that he was regularized on 25th of April 2000. Mr. R. Pujari, Standing Council Revenue, the other end, objects to the submissions of the council for the petitioner. Strongly submits that in the judgment passed by the coordinate bench in so and so versus so, MD Hussain Ali versus so and so. The question before the court was whether the earlier services rendered by MD Hussain Ali as a sub-registrar under commission basis is to be counted towards his pensionary benefits. So Mr. Pujari, however, fairly submits that MD Hussain Ali is in so far as MD Hussain Ali is concerned, the department has considered his case and released his pension under the old pension scheme. So, but in the present case, the writ petitioner has opted for the new pension scheme, which is evident from an undertaking required to be given by the petitioner and which is explicitly mentioned in the notification dated 25/04/2008. By which the petitioner and other persons mentioned there were brought into regular cadre, regular service. So, it is also submitted that periodical deductions towards pension has been made from the salary of the petitioner for payment of pension to the petitioner under the new pension scheme. So there are unappointed query by the court as to whether MD Hussain Ali, who was also brought into regular cadre by the order dated 25th of April 2008, and in whose favor coordinate bench had issued a direction for counting of earlier services rendered under as a sub-registrar commission basis, had given similar undertaking, or whether deductions towards the contribution for under the new pension scheme was also made or undertaken. Mr. Pujari submits that he would like to revert back. He would like to apprise the court upon being posted with these instructions from the department.
I am appearing on behalf of finance, my lord.
Finance,
My colleague is,
sorry, finance.
my colleague,
Mr. J. Hendy.
he will produce it. my lord.
Who will produce?
My lord, he will produce, my lord. Because he is
Mr.
representing the
J.
revenue, my lord.
Appearing for the revenue department as well as Mr. R. Pujari for the finance department, will apprise
Yes,
court upon obtaining the relevant instructions and place it before the court on the next date fixed.
My lord, my lord.
List on 2nd of December.
Thought they would mention, I think their seniors are on their legs, but I was of course hoping that it'll come today because Lordship, we are suffering the stay against the state. Yes, Lordship, it's a big batch. So if Lordship may just come for a moment to Lordship's order only of 21st of August.
1 minute. Let us get the file. What are these matters?
This is the APSC, Lordship. So this is the second batch of the APSC. There was a one-man commission. Then, Lordship, that pursuant to that one-man commission, suspension orders were issued and a DP was started, suspension order. And criminal investigation was going on. In the meantime, Lordship, they challenged the DP and the suspension, and this court gave them an interim protection in December, and January asked for reinstatement. State has moved affidavits, Lordship, seeking vacation of stay because in effect it amounts to giving them the final relief. And so in April, at that time, Justice Suman Sham had fixed a date for final hearing, saying we will hear both the interim as also the final together. So, Lordship, because the matter had got elongated and a stay is against the state and because
Stay of the
disciplinary proceeding.
disciplinary.
Yes, so it's almost a year. I mean, it's about 10 months. So, Lordship, on the last date, on 21st of August, it had come before Lordship's bench. And that day, Lordship, when we had prayed on the issue of there's an interim, I had pointed out that the interim order is there. However, we would like to press for our interlocutory applications. So where we are at the moment, Lordship, is the state has filed for vacation of stay and their main writ petitions are pending here.
Is it a case of disciplinary proceedings not being proceeded at all?
It's not proceeding at all because of the stay of this honorable court. When from broadly, Lordship, show cause notice has been stayed. So in everything will get held up. And this is held up from last year, 2024, somewhere around July, August, September, October, December, it has gone on. So, Lordship, because it's a year of an interim protection, by now, as Lordship would understand, perhaps the disciplinary proceeding would have finished if it was a year.
You tell us what you want to do.
Lord, 26th of November.
Lordship, I'm basically saying, Lordship, that with the stay operating, otherwise, Lordship, we can delink it. I'll argue my vacation of stay.
Not 26th. You can give you the earliest we can give you is 2nd of
December.
December or 4th of December.
Okay.
Lordship, may I request for something? Looking at Lordship's board, Lordship may please be consider maybe my request for 2 days at a stretch. It won't finish in a single day. There are multiple seniors. Because all Lordship, if there is an adjournment sought, then on that day, the vacation applications may be taken up. So if Lordship makes that clear, at least everybody will come prepared for arguments.
No, there's nothing like that. We'll argue.
No, I'm making my submission. It is up to Lordship to consider my submission or not accept my submission. But from the state side, we are, of course, agitated.
Just a passing thought. What is your difficulty if the proceedings are allowed to continue?
No, my lord, how can
restraining them to
no,
pass a
lord.
final order?
Same set of charges, same set of witness. How can the law is well settled?
Okay, there's a criminal proceeding.
Yes.
And on that, Lordship, just to assist, their cases that there cannot be parallel proceedings relying on a certain set of judgments. The state is going to counter-argue that yes, parallel can continue and there are judgments to that effect also, which is why when we had pointed out with a predecessor bench, that time it was felt, let us hear the matter in entirety. As far as the state is concerned, Lordship, our only request is that given that the stay has been operating for so long and disciplinary proceedings are not proceeding, there has to be closure one way or the other. Otherwise, certainly, Lordship, we are pressing for the petition. That's the crux of the case.
My lord, I may just point out, my lord, it is not our case that there cannot be a simultaneous proceeding. But there is an exception carved out by the Supreme Court, that is, if the disciplinary proceeding and criminal cases are conducted on the same set of facts, arising out of same transaction, same set of witnesses are sought to establish a case in both the proceedings, then the Honorable Supreme Court says it is in fitness of things, DP should not proceed. That is the law, my lord. We are never saying that there cannot be simultaneous. There can be simultaneous proceeding, but the exception is that it was carved out in Milord Kusheshwar Dubey, followed till date. So that's the law.
And Lordship,
So
I'll
it's
be.
not our case that there cannot be simultaneous proceedings.
So
Let us
just-
be very clear
So
about
on that also, Lordship, I will point out that the exception that they are relying on does not apply to the set of cases. However, these are our individual cases. We are there to assist Lordship. So if Lordship is keeping it in December, 2nd December, Lordship, I'm just praying if it can be 2nd, 3rd, even 4th, Lordship, just on a daily basis, the matter will require at least 2 days, Lordship.
Yes, Mr. Chaudhary. I mean,
In fact, my lords, I am in some difficulty today, my lords. That's why I couldn't come down, my lords. But these matters will have to be heard. But prior thereto, my lords, there are a few interim applications which my friend Mr. Kohli has said, my lords. 2 applications by the state for vacation of the interim order, and 1 application, my lords, by the petitioner 1564, stating, my lords, that they should first purge themselves of the contempt before they are heard in the proceedings, my lords. So these applications will have to be heard, my lords, prior to taking up the matter for hearing. So, my lords, all I'm saying today is, my lord, today I'm in a mess, some kind of a mess, my lords. Yeah, that's why I'm requesting, my lords, if your lordships can accommodate me for today. And your lordships will fix a date, my lords.
yes, Mr. Roy, anything to submit?
Mr. Roy is, my lords, with me assisting.
So if Lordship, they are pressing for an adjournment, there is a difficulty. Lordship is indicating a date. Whether the final hearing is there or Lordship, the 2 applications, Lordship may indicate it in the order, and I'll request for 2 consecutive days if Lordship would be pleased to consider that.
All right, we'll keep it on 2nd. You argue
Yes, yes.
the interim or the.
Yes, yes.
Would Lordship
Whatever you
make
want
that, if Lordship would be pleased to put it so that we come prepared for the interim. Because Lordship, what happens, there are so many councils and so Lord, let it be placed whether for final, if not, then the interim would be heard.
See, if we come to a finding that in view of the dual proceedings, at this stage, it is better to stay the proceedings.
Yes.
We are there to assist Lordship.
There's no question of.
I am there to assist.
Going for final hearing. The lordship is right.
So Lordship may then, I think, would be.
So whether it will be in the interim hearing or final hearing, we don't know.
We'll see, my lords, that day.
Then Lordship may just come to the 21st order for a moment, Lordship.
We said, yes, we did say that it will require in disposal.
Yes, my lords. After 21st, my lord, much water has
And the
flowed.
next sentence, Lordship.
But it it does not indicate that hearing and disposal of writ petitions, leaving aside the IAs.
Lordship, I'm quite satisfied with that
It does
interpretation.
not even say that it will be hearing and
In fairness,
disposal of the
Lordship,
IAs.
I am quite satisfied with that interpretation, Lordship. Would Lordship may be pleased to consider my
So I
request?
think we may
Second and
start
third.
with the IAs also. We don't
Yes.
If Lordship may please consider my request for 2 days, Lordship. At least what happens when it comes on 2 days, then among all the councils, we'll be able to bring some amount of closure
We'll
to
be
it.
happy to accommodate you for the entire week.
Lordship may please
Provided you
indicate
are
so.
able to spend time in Guwahati for that long.
Lordship, I'll be delighted. Just Lordship may indicate it in the order.
All right, third, Mr. K.N. Chaudhary, Senior Counsel, assisted by Ms. B. Chaudhary.
Ms. B. Chaudhary is assisting Mr.
B. Gautam.
Chaudhary.
Mr. Arunav Chaudhary, Senior Counsel, assisted by Ms. B. Chaudhary and Mr. Roy, A. Roy, as well as for the petitioners, some of the petitioners, and Mr. Kohli, appearing Senior Counsel, appearing for
the state, Lordship.
State
For the
assisted
state
by-
assisted by Mr. A. Roy and Ms. Nimisha Menon. And of course, Mr. Dipankar Nath will always be there to assist.
A. Roy
And
Nisha
N.
Nath
Menon.
and
N.
Dipankar
Menon. N. Menon.
Nath, appearing for the state. Uh, Several IAs have also been filed in the matter. One set of IAs have been filed by the state seeking vacation of the interim orders. Another set has been filed with the petitioners seeking a direction that the respondents should be directed to purge the contempts before
Been heard.
being heard in these matters.
Great.
Let all these matters be listed again, as agreed to, let all these matters be listed again on 2nd of December. On which date the court will proceed to hear the matters.
Yes.
On a day-to-day, if required, Lordship.
And it's interim orders to continue, but
Yes.
Interim orders will continue. If required, the matter will proceed on a day-to-day hearing.
I am so deeply obliged, grateful for that. Introduction.
grateful. Very grateful.
May I please your lordship? My lord, I apologize, my lord, for interpreting in between, my lord. My lord, I beg to mention item 14, my lord, of today's list. It is fixed for hearing. When I am seeking an accommodation for today, my lord. I am representing the finance department here, my lord.
You know that 14 stands deferred. The request made by
My
Mr.
lord, date may be kindly be given.
Arbor Pujari, Finance, and Mr. Ayalam, EPS for the petition at least after 2 weeks.
After 2 weeks.
It's already a fixed matter. You are agreeing to an adjournment.
My lord. He is seeking my lord.
He's seeking, you are agreeing. We are adjourning the matter on the consent given by you. So no fixed date. You make a mention later if the matter is not listed. Mr. R. Dhorford,
PWD, my lord.
PW.
I am so obliged.
Obliged.
Ranking item 8.
Passed over.
Item 13.
May Lord, please. Sir, this is a case for regulation and for pension, the panchayat, municipal board, these are. So, in petition, page 100, I point out this, Lord Chief. Read petition, page 100.
Read petition,
Read petition, page 100. that
page
they-
100.
Yes. So, there is a cabinet decision.
Yes.
So, item 2, here, the proposed staff strength to provincialize in principle 5170 post of 5 categories of ULB, including regular pay scale of sweeper along with corresponding scale of pay recommended by the fourth commission. So in item 2, I am included in 5170 post. So next page is notification of the cabinet decision. 103.
Hmm.
103, here 10th October 2013, this is the notification to Principal Secretary of the Government of Assam, Panchayat and Rural Development, the Commissioner Secretary Government of Assam, Urban Development, the Commissioner Secretary Government of Assam, Guwahati Development Department. So here communication of the cabinet decision in respect of the cabinet memorandum in the recommendation of the group ministers, PRI, ULB and GMC. I am directed to enclose herewith a copy of the cabinet decision 4913 in respect of the cabinet memorandum on the recommendation of a group of ministers on the final report and supplementary report of the firm for Port Assam State Finance Commission on a stepping pattern and locate bodies like so and provincial of service of their employees of taking necessary action. So this is not implemented till today. That's why we filed the writ petition before this honorable court. Lordship, now the honorable court has pleased to pass an order on the basis of this affidavit and all these things on 4th of this 4/4/24. This is the order, Lordship.
Yes.
May I read, Lordship? Hard H. Raman, Learned Senior Counsel, assisted by C. S. Ahmed, Learned Counsel for a petitioner. Petitioner who are 55 in numbers claim to be retired employee of the various local bodies in the state of Assam. On 4/9/13, a cabinet decision was taken to grant certain benefits, including revised pay scale as per ROP on 2010 with prospective effect, and the said decision was duly communicated on 10/10/2013. However, the benefits are not given to the petitioners, and accordingly, this petition filed. It is pointed out by the learned senior counsel that the pleading exchange there appears to be a contradictory stand by the administrative department and UDD and the finance department. In this connection, the affidavit in opposition dated 29/9/21
filed with respondent number 3 on the affidavit in opposition on 28/3/24 by the respondent number 6 have been pressed into service. It is also pointed out that the finance department has taken a clear stand that implementation of the decision of the cabinet is the responsibility of the concerned department. Sri R. Borupujari Learned Standing Council Finance Department, though on principle has not objected to the issue of implementation of the cabinet decision, has however raised a serious objection. That is the point. Serious objection as to whether the petitioner should come within the 5170 number of posts identified by the cabinet decision on 4/9/13. It was submitted that there is no averment of any nature by the petitioner's claim they fall within those number of employees. Therefore, next page, to remove any confusion and doubt, the petitioners are directed to file an affidavit in this regard and also indicate their date of retirement, the post held during the time of retirement, and the urban local body in which they were employed. Sri P. Nayak's Learning Standing Council, UDD, is also directed to seek specific instruction based on the records as regards the aforesaid issue, whether 55 number of petitioners would come within 5170 number of posts identified and recorded in the cabinet memorandum, as agreed by the list 25/4. So on this point, as per direction, petitioners has filed the affidavit indicating their posting, indicate their date of retirement, everything. That is by supplementary affidavit is there. But till today, the state has not come up with the affidavit. Then thereafter, the state was directed to produce the record of this minus everything from 25/4/24, then thereafter 27/1/25, repeated order, Lordship. Then
Where is the order of the administrative, where is the affidavit of the administrative department?
There are two affidavits, Lordship. Administrative department, that is page 120, that is Director of Finance. They filed the affidavit on
Who is your administrative department?
that is urban development.
So have they filed any affidavits?
Yes, they filed the affidavit that is on 29/21.
Yes. What have they stated?
They've stated here that paragraph 5, that the deponent state that so far provincial of the service of municipal employees, as per cabinet decision 4/9/13 is concerned, the finance department did not accept the proposal since the state government gives devolution grant to the local bodies in person of the recommendation so and so. So this is their stand that finance department has not approved. But it is a contradictory statement because the affidavit filed by the director of finance here, it is on 26/3 and 26/3. It is director of finance. They have submitted the affidavit. So here they have stated that as regard the proposal, that's page 122, so paragraph 4. That answering department beg to state that since the implementation of the cabinet decision is the sole responsibility of the concerned department, finance department has nothing to say about provincialization. That is their stand, the finance department. So thereafter, Lordship has directed the state respondent to produce the record of the minus. So I till today they have
Where is that this thing? Where is that cabinet decision again?
Page 100, read petition page 100.
100.
Page 100. And actually. And 103 is a notification. Regarding the cabinet decision, state has no objection. Only they have raised the objection on the day of hearing.
What is page 100? It is an extract of the minutes.
Minus, yes. So they have raised an objection, but because in the latest affidavit, I'll show you lot, sir, that regarding this, the cabinet decision, they have not, only their objection is whether 5170 post our 55 posts is included or not, that is their point, they raised that objection. So that's why the Honorable Court has passed, please direct us to file it stating all the particulars. So we have filed all the particulars, but they never filed this one. Second, latest, they have filed an affidavit that is on Director Municipal Administration. Lordship got it on 23/5/25. It is latest. So here, this is Director Municipal Administration. So he has stated in paragraph 2 that the deponent,
Yes.
that the deponent beg to state that a committee of group of ministers was constituted for the supplementary report of 4th ASFCF staffing pattern, RIS, Provincial Service, 9th November 12. As per recommendation of the committee of group of ministers, the honorable cabinet decision was taken on 4th September 13, wherein in principle approval was given for provincial of 5170 posts. So it is already approved 5170 posts. Only in the context of the aforesaid decision, the Assam Municipal Employees Act 2021 was enacted on 21. Our case is 13, 12 it was cabinet decision was done. So this act, whether it is applicable to us or not, because no act has been a retrospective effect, it is a prospective effect. So here they have taken a stand, the 5170, that is already they have admitted 5170 post that is ULB on the cabinet decision was 4th September 13. Lordship got it. So in the context of the aforesaid decision, the Assam Municipal Employees Act 2021 as enacted on 31st May 21. Original 1653 number of employees who were found to be in service. Employees posted regular sanction post ULB appointed prior to 4th September 13 were proposed to be converted under the ambit of this case. So even if their stand is correct, then our appointment was before 2013, because on the day of filing of the petition, we have all retired. That is our case. So here, Lordship, I like to place some of the Supreme Court decision regarding this provincial.
Let us understand the facts properly.
Lordship.
Page 100 is the cabinet decision.
Lordship.
What is the effect of the cabinet decision?
Cabinet decision till today they
That
have not.
5170 posts.
Post.
For 5 categories of ULB, what is ULB?
The urban urban
Local bodies.
Yes.
Recommended by 4th.
So posts were collected by various departments, town committee, municipal committee, everything. So cabinet has approved that for regulation of the 5170 report. Now the respondent raised an objection in the course of hearing that whether 5170, our 55 posts is included or not. So accordingly, Honorable Court has passed an order directing us to file an affidavit. So accordingly, we filed an additional affidavit stating all our particulars, name of the post, then everything is there, date of retirement. So additional affidavit.
No, but whether your posts are included or not would be available in the cabinet memorandum.
No, yes, cabinet memorandum that is available and the record is available.
Right. Then
now there is a state to produce the record. Whether that 55 posts is included in our. That is our.
Yes, state.
If Lordship comes to page 100, Lordship, that is Annexure B, that is the cabinet, I mean the extract of the cabinet decision, Lordship. Lordship, if Lordship comes to serial number 2.
Yes.
Lordship, 3 components are here, Lordship. One, PRIs are there, ULBs are there. At the same time, GMCs were also there. If Lordship comes to serial number 2, the proposed staff strength to the provincial to provincialize in principle 5170 posts for 5 categories of ULBs, including regular scale of pay for sweepers along with corresponding scale of pay recommended by the 4 Assam State Finance Commission. That recommendation was already there. That is only a extraction. If Lordship comes to 3, this relates to GMC. So we are not concerned. Lordship may come to 4, serial number 4. Salary provision for the provincialite ULB employees, for the provincialized, including GMC, will be made out of their devolution grants under the relevant head of account of the budget provision of the concerned department and not under grants in aid head account 3604 compensation and assignment of local bodies. So it was clarified where from the salary amount will come, not from the state government, but from the Assam State Finance Commission, that is the devolution fund. If Lordship comes to 5, the employees of the ULBs will be given.
Gives the devolution grant?
Devolution, Lordship, it's a three-tier government, Lordship, 74th Amendment. They are municipal bodies. Just like PRIs, they are municipal bodies. So 73rd Amendment, 74th Amendment.
No, devolution grants are granted.
Devolution grants are recommended by the Assam State Finance Commission. And on the basis of that, payments are made to the respective municipal bodies.
By whom?
By the state government, but not from the state government fund.
Alright.
If Lordship comes to 5, employees of the ULBs will be given revised pay scale as per ROP 2010 with prospective effect from the date of notification.
Alright.
Lordship, where is the notification?
No. Who is to take out the notification?
State government.
So
But
who-
state government never issued any notification.
So why did you not issue? Unless
Lordship,
you
I am
disown-
what I am submitting, Lordship.
Unless you
Yes,
disown a
a
policy
a
decision.
decision was there,
Yes.
but that decision was never given effect.
Then you should explain why it was not given effect. It's a policy decision.
That is one, Lordship. Lordship, direction was issued for
Once a
furnishing.
policy decision at the highest level is taken,
Yes,
there is no bar for revisiting this policy decision,
yes.
even today.
If
You
Lordship,
revisit
if
it,
Lordship
you
comes
may
to the,
modify or
Yes.
recall.
if Lordship comes to the affidavit filed by the Finance Department, the reason is there, Lordship.
What is the reason? Director of Finance.
Director of Finance,
Yes.
page 121.
121.
First portion, my learned colleague has already read, Lordship, paragraph 4. Lordship, I am coming to page 122. However, second paragraph. However, as regards proposal for provincialization of the employees of urban local bodies, ULBs, keeping in view present resource position, Finance Economic Affairs Department, with due approval of the higher authority by the endorsement dated so and so, stated that the proposal for provincialization of the employees of urban local bodies may not be acceptable for Finance Department for the following grounds. So one first objection came from the Finance Department. Thereafter, Lordship, if Lordship comes to
For
the
what reason? Read the reasons.
reasons are there, Lordship. First reason, if the government takes decision for provincialization of the employees of urban local bodies, there is every possibility of initiating such proposal for Panchayat and Rural Development Department for 23,790 employees for Panchayat institutions and Guwahati Development Department for 2,706 employees of Guwahati Municipal Corporation. Since the state government gives devolution grant to the local bodies in pursuance of recommendations of the State Finance Commission, there is no logic for provincialization of the employees of the local bodies. 3. As the 73rd and 74th Amendments of the Constitution of India have accorded separate status of government with specified powers and functions to local bodies, provincialization of services of the local bodies runs counter to the spirit of the Constitution. So those were the objections taken by the Finance Department, and the decision taken in the year 2013 for provincialization were never given effect to.
Who are you to object the policy decision? You are only an implementing department.
Yes,
So you-
implementing
you
department is
don't-
the,
Can you override a policy? Policy is taken by the state.
Highest authority.
yes,
You may raise your objections before the authority.
but the law is that, Lord.
What is the law?
Law is that until and unless a policy decision is notified.
The
with-
question is there's no dispute with this proposition of law. The question is, why have you not notified it?
Not notified because some
Are you-
objections were raised.
are you under which source of the law or the provision is an implementing department authorized to refuse to notify or to implement an action in terms of a policy decision taken at the highest level of the state.
Lordship, at this stage, Lordship, I think I'm not going to the reasons why it was not notified because of the subsequent facts.
Hmm.
Lordship, in 2021, Lordship, one notification was issued
Hmm.
for provincialization of the municipal employees. If for that, Lordship will have to go through the record, Lordship. 2021. A decision of 2013 was there.
Hmm.
Their Lordship number of posts were 5,700. In 2021, one notification was issued. I can read here.
What relevance has it got here?
Because it is on the same subject.
Huh.
And the effect of that notification was that only those employees who were working, only their services will be provincialized.
Why have you not brought it on record? If that is the ground on which their cases are not
It came to
considered.
my notice only after going through the record only.
You bring it on record. Why should we examine your records or a particular document in the records
Lordship.
when we have not even directed you to produce it?
Lordship, that I
You have been filing repeated affidavits after affidavits. Look at the affidavit filed by the department. Which department is it? Urban Development.
Urban Development. Lord.
After the bank file with Director Municipal Administration.
Where is the Urban Development affidavit?
It is Lordship 27 May 2025. That is there on record, Lordship. If Lordship comes to paragraph 2.
See paragraph 4. Read paragraph 4. Last line.
Lordship is reading 27 May 2025 by Tonkeshwar Das.
No, this is 23rd of September 2021. Respondent
If
3.
Lordship may kindly come to the last affidavit, Lordship. By one Tonkeshwar Das, Lordship, he is the Director, MAD, Municipal Administration.
No, this is the Commissioner to the Government, Urban Development.
Yes.
So read his affidavit first.
I'm taking this last affidavit because these facts are mentioned here, Lord. This 21 and 2025, both are.
Where is the last affidavit?
This is page 136.
23/5/25.
27/5,
23.
Copy this, I had it, yes. 136.
Yes.
Paragraph 2, Lordship, page 137. That the deponent begs to state that a committee of group of ministers was constituted for supplementary report of the 4th Assam State Finance Commission on staffing pattern of PRIs, ULBs and GMC and provincialization of their services on 9 November 2012. As per recommendations of the committee of group of ministers, honorable cabinet decision was taken on 4th September 2013, wherein in principle approval was given for provincialization of 5170 posts for 5 categories of ULBs. In the context of the aforesaid decision, the Assam Municipal Employees Act 2021 enacted on 31st of May 2021 or originally 1653 numbers of 1653 numbers of employees who were found to be in service employees posted on regular sanction post of ULBs appointed prior to 4th September 2013 were proposed to be covered under the ambit of the Act. The Honorable Cabinet on 10th January 2025 instructed the Department of Municipal Administration, Assam, to prepare a draft bill in consultation with the School Education Department and also for repealing the Assam Municipal Employees Act 2021 as it poses some legal impediments. In the line of the above, the Honorable Cabinet on 5th February 2025 gave approval to the Assam Municipal Employees Provincialization Bill 2025, which seeks to provincialize the services of 1044. Lordship, may kindly see the numbers are decreasing. Initially, it was 5,000, then it was 1,600, now it is 1044. Employees presently in service, regular employees posted in 71 ULBs appointed on or before 4th September 2013 under general areas and repeals the Assam Municipal Employees Act 2021. The Assam Municipal Employees Provincialization Bill 2025 was tabled and passed by in the Assam Legislative Assembly on 6 March 2025. But this bill is yet to be notified. Subsequently, it has been notified, Lordship.
Notified as a what? As an act?
Yes, Lordship. Gazetted.
As an act?
Yes, Lord. It was 16th of June 2025.
Whether it is a prospective effect or retrospective effect.
Prospective. However, the petitioners were not included in the 1044 employees under the Assam Municipal Employees Provincialized Bill 2025, as they had retired from their service before 6 March 2025.
Where is that act?
এখন কপি দিই, 2 নম্বর এখন দিই এখন এখন মই দি আছো Lordship, it was notified on 16th of June 2025.
Date of effect.
1-3, Lordship, it shall come into force on such date as the state government may by notification in the official gazette appoint, and different dates may be appointed. It was notified on 16 June 2025.
25 only, whether it is a retrospective effect or prospective effect. Can you clarify it?
If Lordship comes to 3, serial number 3. The following categories of employees shall be eligible for being considered for provincialization of services, namely 1. He or she is an employee of the board recruited on or before 4th September 2023. Lordship may kindly see. Next page, Lordship.
This is with regard to Assam municipal employees.
Provincialization Act 2025.
This is, these employees will mean employment under the municipal board.
Lordship, though it will consider those employees who were appointed prior to 4th of September 2013.
Municipal board includes the urban legal body, local bodies.
Urban local bodies.
All right.
So if Lordship comes to the next page, Lordship, that is serial number 4, provincialization of employees of the municipalities under state government. Roman 3, small Roman 3.
He or she is an employee.
Is an employee.
Recruited on or before 4th of September 2013.
So as on the date of notification, he has to be a serving employee.
No.
He or she is an employee of the board recruited on or before 4th September 2013. 2 part is an employee recruited prior to 2013. That is 1. And if Lordship comes to the next provision 4,
where are the objects and reasons? Objects and reasons are not here.
an act to provide for provincialization of the
No,
services.
this is the title, preamble.
Yes,
There
preamble.
must be, there will be an objects and reasons.
For that, I think Lordship will have to go for the memorandum, Lordship.
No.
Approval.
It should be there along with. Because this defines why the act, why the legislation has been made.
Yes,
This is
Lordship,
the
that should
object
have
and
been,
this is the
Lordship, but
reason.
it is not here, Lord.
Not-
Like if Lordship comes to serial number 4, Lordship, section 4, Roman
See, for
3.
instance, if you read the initial opening lines,
Yes, Lord.
act to provide for provincialization of services of employees working in municipal constituted under Municipal Act 1956.
Yes.
Now, does working means previously working?
That, no.
Is it defined
Working,
specifically?
if Lordship comes to 311, then Lordship.
No, 311 is okay. Anywhere else that which
four-
shows that
four-
why
4-3, Lord.
this legislation has been
4-3.
4-3.
Covered. That's covered. Okay. Yes.
Okay.
So in my
So
understanding,
it
Lord-
excludes your clients.
No, no.
4-3.
No, Lordship, let me clarify, let him submit, I'll clarify. Because.
No,
our-
I know we'll hear you in detail, but what I want to
our-
know is
Yeah,
that,
our appointment is
no,
prior to
your,
13.
listen, Mr. Rahman, please understand the queries of the court.
Lordship,
The first thing is that there was a policy decision
right,
taken by the cabinet.
cabinet.
Nothing happened after that.
Yeah.
Now they have come up with an act where they've excluded people who were in employment of the municipal board, including your clients, prior to that effective date. They have given an effective date, 4th of September 2013.
So, just a minute, Lordship. 4th of
Coupled with,
September.
coupled with
4th of
section
September.
4(3).
No, our additional affidavit, we have clarified the, our date of appointment and everything. Lordship got it in this affidavit that all appointments are, our appointments were from before 13.
No,
And Lordship, this is, that's it.
your appointments are?
Before 13.
That's right.
But we are retired. That is the point.
So the question is now whether this act excludes you or in view of the earlier decision, whether you are still included.
Lordship, may I clarify, because Act is 25 Act. Our case is 2013 policy decision. But this act has come into retrospective or prospective. That is not there in that
No,
act.
no, that is not there. That is
Not
for
in-
you to find out.
that is not there.
That is why we want to know the objection reasons.
That is not there, yes. That is not there.
This is available on public forum. This is available on
No,
the
just-
web
just-
portal, or if you apply for copy of this act, this is available.
No,
You can find out and tell us whether this act specifically excludes people who have debited office or retired office earlier.
But Lordship,
And if it does, then the question would be, you'll have, if according to you, see, this act follows a cabinet decision of the state.
Right.
This act will come into force only once a decision is taken by the cabinet.
Cabinet, yes.
So does it mean that this subsequent decision to bring this act can be termed to have overruled the earlier decision or modified the earlier decision?
That is not clear in this act.
So that
Is what you
will
said, no?
be clear only when you examine the question whether this act includes the persons who had worked earlier and retired. Section 4(3)
4(3), yes.
clearly excludes
Yes. Section 4(3), yes.
who have completed 65 years of age
Yes.
on the date of coming into force.
And deemed to
They
have been-
shall have no claim.
Yeah.
So it is open for you to assail this if you want.
Yes.
Lordship, even before 2025, Lordship, another act was there in 2021. Therein also number was 1605, 1607 or something like that, Lordship. Initially, it was
No,
5,000.
whether it is 1605 or 5607,
Lordship, what I am
we are not
submitting, Lordship,
concerned.
what
We
I
are
am
concerned
submitting,
is
Lordship,
whether the decision of the cabinet as they have presented still remains.
No.
Or can it be interpreted to say that subsequent legislations
yes,
have watered down the earlier cabinet
yes,
decision?
that is my submission, Lordship. Lordship, what I am trying to say, Lordship,
It appears to be so. It appears to be so that the earlier cabinet decision was slowly watered down or allowed to be watered down by the subsequent legislation. Now it is up to you to decide whether you want to put a challenge to
In
this.
this point, Lordship, I like to place some decision of the Supreme Court that even if we retired, we are entitled for the benefits. So this Supreme Court decision is there. Gujarat High Court decision, then Gujarat ET went up to the Supreme Court. Supreme Court said clearly that even if retired, the two criteria is fulfilled, that 10 years completion of service, then I'll place the judgment, Supreme Court judgment. Thank you. This 2019-12 SCC 340. This I am forwarding.
Yes, we have a copy.
I said, Lordship.
Yes.
Here, the municipal and village service pension, pensionary benefits, entitlement of. Division bench relying on a Mohammed Irsad Hussain Baslo, 2011 SCC online, against which SLP were dismissed by Supreme Court, by order that it held rightly found respondent employees of appellant municipality is entitled to pension and pensionary benefit. Held no interference with the impugn judgment called for. Further held distinction sought to be made between two groups of employees, one coming from the panchayat and thereafter becoming municipal employees, and the other direct municipal employees, insignificant since appellant had made respondent member of GPF, contributed and was making regular deduction from their salary. Furthermore, reliance on circular dated 28/11/94 also inconsequential since it was not filed before the courts before and it applied to panchayat employees who later became municipal employees. Appellant directed to release pension within stipulated time. Entitlement of pension, paragraph 21-24. Here, that paragraph 5, paragraph 5, and that on the age of attaining the age of superannuation in the appellant service on different dates, all the 5 respondents requested to the employee to settle their claim for payment of pension and pensionary benefits. The appellant declined to grant any pensionary benefit to all the 5 respondents, stating that they were neither eligible nor entitled to claim the pension and any pensionary benefit from the appellant. Then next paragraph, I'm not going to that skip up, that paragraph 9. It is opposite to mention that the very question, namely whether an employee of a municipality is entitled to claim pension or pensionary benefits from his employee municipality, was the subject matter of one litigation in the Gujarat High Court. The leading judgment was passed by the division bench in LP Chief Officer of Mohammed Irsad Hussain, along with the other connected matters. The division bench held that the employees are eligible for thus entitlement to claim pension, pensionary benefits, provided they render qualifying service while in employment of the municipality in terms of the rules. The municipality concerned felt aggrieved by the said order and filed special leave petition by the municipality in this court. If was however dismissed by the court by order dated 16/9/13, and the order accordingly given effect to the sanctioning and pension to those employees who were parties in the said litigation. It is the background when the petitioner out of which these appeals came up for hearing, the single judge Reed Court essentially placed reliance on the decision of Chief Officer of Mohammed Irsad Hussain Baslu and allowed the petitioner finding no material distinction in the case at hand and the Chief Officer of Mohammed Irsad Hussain. When the matter came up for appeal, the division bench also placed reliance on the view taken in the Chief Officer of Mohammed Irsad Hussain and dismissed the appeal. The Reed Court and the division bench were of the view that the issue in question was attained finality by the decision rendered by the Chief Officer Mohammed Irsad Hussain Baslu and affirmed by the order of the court dated 16. So next, I'm reading that paragraph 9. The division bench, while repeating the aforementioned submission, take note of the following 4 with undisputed facts arising out of this case. The original petitioner respondent and wherein our respective appeals were appointed by the municipality and they were in service of the municipality, number 1. Number 2, after the appointment, the employees concerned continued in service till they reach the age of superannuation. So far, the LPA number 1066/2015 is concerned, whereas in the rest of the later present appeal, the service of the employees concerned came to an end on account of the death of the employees. It is undisputed position that the total length of service in respect of all cases has exceeded 10 years, which is a minimum requirement for eligibility pension. In respect of all employees, which is subject matter of the present group of appeals, they were member of the GPF and GPF contributions were being deducted by the municipality from their salary from time to time. So our also GPF deducted. 10 years we have completed. The division bench was in the view that, in our view, rightly that the distinction sought to be made between the two groups of the employee, namely one coming from the panchayat and then are becoming the municipal employees, and the other directly become the municipal employees, was held to be the so significant because of the appellant made the respondent member of the GPF contribution and went on deduct regular contribution.
Mr. Roman, with all respect, this judgment is not on, this is not an authority for what you're submitting before the court. This judgment is not an authority. It doesn't help you in buttressing your arguments.
No,
Your arguments are that there's a policy decision that was not implemented. Now, in view of the new act,
That is true. That policy is not
This
in place. That is why I
judgment-
filed a writ petition.
this judgment
But
only.
ratio of the judgment is
No,
applicable
what
to
is
all.
the ratio? That's what we're trying to understand. The
That-
ratio of the judgment is
10 years service.
that, no, the ratio of the judgment is that since Gujarat High Court in a different case had already upheld
Yes,
in a division bench
yes,
that the employees are entitled to pension.
pension.
Subsequent
went
claims
up to-
made
Yeah.
by these appellants or respondents
Yeah.
before the Gujarat High Court, placing reliance on that particular earlier judgment
Mm.
was upheld by single bench and division bench, and the SLP was filed.
By
The
the,
court held that the earlier judgment,
will.
whatever has been held, was correctly held.
so ratio is that they have already clarified 10 years.
No,
complete
this is
service.
not the ratio here.
Yes, also, because
No.
it is already.
No. This ratio which has been clarified is because of the finding of the division bench in the earlier judgment of that Hussain Bhai. Mohammad Irshad Hussain Bhai Baloch was a separate judgment where certain findings were arrived at.
Yes, but regarding the
The,
pensionary
the
benefits.
single bench, division bench of the Gujarat High Court relied on the judgment to come to to give the reliefs to the respondents,
Not,
which was challenged before the apex court, and the apex court said that there is nothing wrong there. In your case, you are not relying on any other earlier judgments where this issue has been
no,
settled.
that is true, but
Uh.
suppose the principle laid down here is applicable to my case because
No, then you have to refer to this Hussain Bhai case.
no, here Lordship, we have in our affidavit, their objection is we have not completed the service, we retired. As per the present act also, they have, there's 4, they have said that prior to 1/1/13, we were appointed. That is there. But our case is we have retired. Act is says, they're existing employees. So that is the difference. So when we have retired, but appointment date is prior to 13, so definitely as per this ratio, we are
That
entitled.
is a challenge you have to address before another forum by putting a challenge to the new act to say
No,
that
new-
your
the
services would
Lordship,
not have been excluded.
New act come into existence after during the pendency of the case.
Then
Case-
on what basis are you making this claim? On what is the premise on which you are making this claim that you are entitled to salary? Only on the cabinet decision?
Cabinet decision, yes. Only
So
on the
that
cabinet decision.
cabinet decision was never implemented.
No,
Subsequent.
Lordship, whether it is whether it is implemented or not, it is the court to call for the record. It's 100 times court pass the order for produce the record.
We
Records
did
are
not
why.
call for the record in
Yes,
view of the
Lordship
subsequent
order is there.
orders.
Lordship, you kindly see the Lordship's order from court.
Mr.
Lordship calls for
Mr.
record.
Roman, please understand.
You can lift the veil.
No. Please understand, it is the submission of the council saying that we did not implement it. It is their submission. They are not.
Let them file an affidavit. Let them file an affidavit. They have not specifically not denied.
They have decided that.
No, where the
last
affidavit? No, where is the affidavit?
Where is the
If
last
they have not filed
affidavit?
the affidavit with the 20, in this also I have placed a judgment, division bench judgment of our High Court. The affidavit, without the specific denying, they cannot file.
Where is that affidavit?
Yes, I-
27B,
Director,
Pankaj, yes,
it is there.
paragraph 2.
non-implementation not there. Kindly see the affidavit.
They have stated it in paragraph 2 or 3.
No,
2 lot. Specifically stated about the two enactments, Lordship,
Only
121,
their objection
125.
was during the course of hearing, they have raised one objection that whether on the post
No,
of.
Mr.
What-
Roman, let me understand your contentions. Your case before this court is that once a policy decision is taken, why has it not been implemented?
Not implemented.
That's your case?
That is the case.
Right. Now that they have explained that we cannot do it for X reason, Y reason, but finally this
No.
statute has come in.
No, Lordship.
The statute has come
Let me complete, Lordship.
This
Prior
statute-
filing of this affidavit, 25 affidavit,
Uh,
the Lordship see the order court order from this court
What order?
on 4th of this. What was the direction from the court?
A direction from the court was to.
No, if court's order is not implemented, till today they
Directed
have not
to
produced the
6.
record, yes.
Hmm.
Here, P. Nayak, Land and Standing Council, it is also
No, no,
directed to
is
seek
it
specific
your
instruction
case?
based on the record.
Is it your case that subject to correction, instructions from your clients are that there
No,
is a
not the
specific,
client, it is the court direction.
please listen to the query raised by the court. is it your case that from instructions from your clients that there is a specific order or orders whereby this cabinet decision has already been implemented, but it has not been acted upon? Is it your case that the
That is
records
our
called
case.
for will reveal?
That is our case. That is our case.
I don't think that is your case.
No, that is our case because now their stand is the 5170 post. They have identified. So out of that, whether 55 post is there or not, that is their query.
No, we are asking you again, is it your case that cabinet decision is not implemented?
Not implemented.
Or is it your case that cabinet decision, subsequent to the cabinet decision, notifications or orders were issued, those are not being allowed to be implemented? Which is your case?
My case is not implemented.
What is not implemented?
That cabinet decision is not
So
implemented.
cabinet decision, they have already admitted by way of an affidavit that these are the reasons why we are not admitting. You may accept, you may reject, we may accept, we may reject, is a different issue. But prima facie view of the court is that in view of this new legislation, cabinet decision earlier taken appears to have been reviewed or revisited. Now your claim
Then
is,
only we have to file a separate cause of action. Now,
you may have to file, if you have to file, you have to file.
Lordship, very unfortunate that from 19 cases pending, again, 5% has died, and again, Lordship has directed me to file a separate.
We are not directing you.
But
We are not directing you.
because 55% from 19 retired person, they are fighting. They are struggling.
You, as a astute senior counsel, you know emotions don't make a good law.
No, this
It is not just emotions that will,
Like,
that will allow a law to be
Lordship, for 30
chartered.
years I'm practicing,
Ah.
that emotion I have not shown it.
That you are
But this
displaying
is
it now.
from the client
displaying it
condition,
now.
stable condition, it is a boundary.
You show us any judgment of this court as well as the apex court to show that once a cabinet decision is taken, it must be implemented. And the government does not have the right to go and revisit the cabinet decision.
Lordship, exactly on this point, Lordship, I am placing one judgment.
Place it.
This is by our High Court, Lordship, in WPC number 3782.
It is because we thought we wanted to give you some relief. But the question is that once an act is come, unless it is challenged, there is no scope for us to consider whether the provisions of the act is correct or incorrect. Yes.
Paragraph 12, Lordship.
Or which
Paragraph 12.
judgment?
This is WPC 3782/2024. I'm coming to paragraph 12, Lordship. This is Article 166. I'm skipping the provision, Lordship. I'm coming to the next page, Lordship. Paragraph 12. Later portion, Lordship. Article 166. Next page, Lordship. Of the Constitution provides that all executive actions of the government of a state are to be expressed in the name of the governor, which includes order and instruments. A reading of Article 166 of the Constitution basically provides that the state government would have to issue orders and instruments in the name of the governor for the state action to be made enforceable in law. There is nothing provided in Article 166 that a cabinet decision which has been crystallized into an order, notification, or any other form of instrument in terms of 166 can be said to be the conduct of business of the government of a state. If next, Lordship comes to the next paragraph, 13. In the case of JP Bansal versus State of Rajasthan reported in 2003 5 SCC 134, the Supreme Court has held that the Constitution requires that action must be taken by the authority concerned in the name of the governor under Article 166 of the Constitution. Unless the above formality is observed, a cabinet decision cannot be regarded as an action of the state. It further held that the Council of Ministers are advisors as the head of the state. The governor is to act with the aid and advice of the Council of Ministers. Therefore, till the advice is accepted by the governor, views of the Council of Ministers do not get crystallized into the action of the state. So these are the paragraphs, Lordship. Paragraph 15 is the conclusion, Lordship.
You share some copies to the counsel for the petitioner also.
13, 14, and 15.
Yes.
But in the same
If
judgment.
you want to go through the judgment, we'll give you
Yes,
some
yes,
time.
Lordship kindly read paragraph 15 in the same judgment.
Paragraph 15.
15.
Yes. Mhm.
From third line.
Oh.
Fourth line. Thus, when there is no government order implementing the cabinet decision, the same cannot be said to be enforceable in law, in as much as the said cabinet decision can only be said to be provisional in nature, which can be changed by the Council of Ministers on reconsideration of it.
That is what we are trying to tell you.
In our case, that is
That the effect of a legislation being brought is an indication that the original cabinet decision has been.
That Lordship, with due respect, one thing I like to point.
The
out.
only thing
Regarding
no,
this thing.
this is a tentative view because the objection reasons are not here.